Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And we already have a panel going today. We've got Mr. Uncivil Law, Mr. Matt Wilson, and Runkle of the Bailey. How are you guys doing today?
I'm doing great.
Little tired, but I didn't want to miss anything given if they're doing anything interesting, it'll be right off the hop. So I was like, I got to wake up for this.
I'm having a ball, guys. Ready to be here.
I saw you were on Twitch last night watching a movie or something.
Yes.
You're glutted for punishment.
We watched Major Pain. I love that movie. So good. So good. It's a classic. Damon Wayans. Wait, no. Is it Damon Wayans? Yeah, I think it's Damon Wayans. And just refreshing to watch a 90s sort of probably teenage movie or adolescent to teenage movie, and not just hate everything about it, but actually laugh the entire time.
I actually remember seeing that in the theater. Shows you how old I am.
Oh my gosh, you're the only other person than my dad who says theater. I love it.
Well, down here, that's what we call it in Mississippi.
Yeah. Oh, by the way, yes, since you are new to the Rittenhouse streams, maybe you could introduce yourself to the chat so they know who you are. Just a little brief bio or whatever.
Well, my name is Matt Wilson. I'm an attorney in Mississippi, and I do what I like to call the unusual and the oddball cases. Uncivil law will tell you that. I've handled, if it's odd, if it's crazy, if it's unusual, if it's the type of stuff that an attorney in Mississippi doesn't want to take, I'll be the one to take it. I won't get into the stuff I've got right now because that's not what we're here for, but I've got some really big stuff doing.
And I've told you before, it's like I find what you do just like a lot of fun because you deal with this like esoteric stuff. It sounds like so much fun.
Oh, it's like sarcasm. I put sarcasm in my briefs.
Oh yeah.
Witty.
Oh no, this is I want to be sarcastic in briefs too. It's like this is what I want to do in my life. They won't let me know.
I made you laugh your butt off on your show one night.
Uh-huh.
He read one of my pleadings and he just laughed out loud. So
I've done that too, but I think for different reasons for different people. Because I read the pleadings of this lady named Melinda Scott, and I can't stop laughing at them. But I don't think it's for the same thing. It's not because she's inserting sarcasm and wit into her pleadings. It's because they're insane. Well, I'm very glad to have you on the.
And I'm honored to be here.
All right. Well, I mean, maybe. Honored's maybe a stretch. No, I'm just kidding. We've had such an amazing turnout of people to watch these things. Today we have the jury has been dismissed for the weekend. They get to go home. They get a 3-day weekend. They get to try and piece their lives back together after 2 weeks of not having jobs or anything like that, other than going to a courthouse and being maybe secretly recorded by weirdos as they get on a bus from the grade F security plan of the court for keeping a jury secret when there's 1 million people watching.
Yeah, just put them on the bus that just says jury right on it, you know?
It's like at least get 2 buses and have one be fake. Right? Have one get out and everybody's in banana suits or something, but then have that one be the actual jury. That'd be the trick. That'd be the way you do it. And you put a bunch of normal looking people on the other bus that says not the jury. And then people will be like, oh, that's definitely the jury. I could do this no problem. But so the jury has been let go. And today, and I do see at least one live stream set up. They are doing the jury instructions and motion arguments in front of the court. Will we see the motion for mistrial argued today? That's the question.
We better, or I'm going to do a public freak out. I'll tell you what.
Yeah. It's, I forgot to button my...
As I think we've all made a point of noting, it's pro forma in every case. Even the most loser case, you make the motion. Because you never know. Maybe the judge slipped on the toilet that day and is confused. The fact that they haven't made these motions up to this point is bizarre. If they don't make it today with this kind of record, yeah.
You know,
Oh, go ahead.
I'm sorry. It's
No
been
worries.
my experience that you win your case or you lose your case when it comes down to jury instructions, because I practice law in 2 states, in Mississippi and Tennessee. Now, in Tennessee, the cases that I've tried up there, the judge does the jury instructions, or at least the one I went before. He would stay up all night at his house and write his own jury instructions, and we didn't really have a say in it. But in Mississippi, you have to submit your jury instructions, and the times that I've tried a criminal case or two, the time that I tried a criminal case down here, the judge was, he took the prosecutor's jury instructions, rejected every last one of ours, and there you have it. I mean, so this is going to be very critical today. If Rittenhouse wants to win, he's going to have to win by virtue of what is instructed to the jury.
Yeah, I think that's pretty accurate. Well, I mean, of course it's accurate, but it's apt, particularly in this case, because we have a couple of the charges have really confusing jury instructions, and so the prosecutor and the defense's ability to argue for how these jury instructions are crafted is going to help break down to normal person speak, and that's the jury, how these charges are supposed to be decided. The particular ones that I know we've talked about so far are the reckless endangerment charge for McInnes, which is a baffling charge because it involves self-defense, and that's not supposed to be allowed in reckless endangerment except when it is, which is weird. And they had a brief argument over that at the beginning of the case, if you didn't see it, and we'll see it back today, I'm guessing. And then the other one, of course, is the minor in possession of a firearm charge, because there's an exception built into the law, and the prosecution has argued, apparently, that exception should be decided by a jury and not by the judge, which is, again, particularly insane in my opinion. And I am very surprised that Judge Schrader agreed with that argument.
It seems bonkers just reading. I mean, they're asking the jury to interpret the law. That's not what happens, to my knowledge.
Yeah, it's and I'll do a very brief summary of that issue. The issue is that if the jury instructions are normal in the minor in possession of a dangerous weapon, I should say, not a firearm, dangerous weapon, the jury instruction would be, is the defendant under 18 years old? If yes, is the defendant in possession of what is labeled a dangerous weapon under the law? And in Wisconsin, that includes specifically firearms. However, that'd be the normal instruction. There's a subset of instructions. It's section 3C of the statute. How's it going, Joe? Oh, he can't even hear me yet. Can't even hear me yet. It's section 3C of the statute, and that has an exception for when the dangerous weapon. Welcome, buddy. That exception is for when the dangerous weapon is a long-barreled rifle or a long-barreled shotgun, which just means standard length or longer barrel. And that's what Kyle had. So that exception should trigger. And then it has basically, if they are 16 or 17, then they have to be in compliance with a hunting statute. And the question is, should they be required to follow that statute if they're not actually hunting? My contention is no. It doesn't seem to have a requirement for everybody in possession of a firearm to comply with a hunting statute. That doesn't make any sense, but we'll see. And so we know the facts of the case. There's nothing for a jury to decide about it. Kyle's under 18. He's in possession of a dangerous weapon. And even under the exception, he is not in compliance with the hunting statute. So the only question is whether or not the statute even applies. And that's what the judge should have answered.
It's straight up legal question. Yeah, it's straight up. It's like, okay, he's in possession of a non-short barrel or long gun, namely the rifle. He's under 18. Okay. Does the exception apply or not? It's a straight up legal question. What's for the jury to determine here?
I don't know. But we will find out today when we get those jury instructions.
Maybe if they stipulate on the record that he, as to his age and the fact that he was in possession of a gun, and then ask the court to make a ruling instead of saying let the jury decide. All right, now you make a rule.
I don't know whether it's wise or not in the grand context, but you could even make a colorable argument that the defense should basically plead guilty to that charge with the right to appeal on the underlying legal issues, to take that issue away from the jury so as to not confuse other legal issues. Like, you don't want that he was in possession of an illegal firearm floating through the jury as they're considering other issues. We all know as lawyers it doesn't impact the self-defense analysis. We all get that. But I was just saying that, if you take that away from the jury and say, okay, we'll plead guilty to that charge, reserving our right to appeal on the underlying legal issue, so they're not having that floating through their mind. Maybe that's a tactical consideration that makes sense.
Or an opposite tactic. An opposite tactic could be, if the jury feels unsettled about the idea of letting him walk away altogether, if you leave them that charge, in that case, they can just be left by saying not guilty on all counts.
I agree, Joe.
And then he's guilty. He's guilty on the possession. You agree with that?
I do. I mean, because when you're dealing with juries and it's a polarized situation where you've got half the people who think he's guilty of something and he should go to jail for this, and half that don't, and they're in a kind of a log jam and they want to have something to compromise. It's easy to point out this one thing, this lesser included. And if it's a lesser included, usually it's like a manslaughter or something like that. But if you can get it down to something like possession of a firearm illegally, then they go away thinking they've done something. But if it's still straight up murder, straight up reckless endangerment or whatnot, and they have to decide, then you've got a problem, because sometimes they may decide against you.
Yeah, but at this point, it's no longer straight up, because now we have these lesser included that are being brought in, and I'm not exactly sure what those are.
Yeah, I agree.
They're bringing in some lesser included, so they might compromise by reducing the murder charge to an aggravated assault instead. Yeah. So there's that factor now as well.
Yeah,
of course, in the complete abstract, if all you have is the straight up murder charge, and you don't have a lesser included, then it's a gamble.
Yeah. This is of great discussion for me, though, because it's just going to show some of these strategic considerations, and I'm loving the panel's different thoughts than mine, because it just goes to show some of the factors lawyers can consider. So. Mm-hmm.
And that's the other thing we're going to likely see today. The state will list out officially. They may just be. What's up? Just a second, guys. I gotta go.
I will tell you. Okay, I'll try. I got your back. I'm picking you up. You're welcome.
There you go.
You're welcome.
Lead the charge. Good logic.
Yeah. No. So, the interesting thing about what you were saying just now, with the fact that different people have different perspectives, the annoying or blessing, I'm not sure if it's a good thing or a bad thing, is that we each can come up with a different strategy here, and there's no way anyone will ever know which of us is right. Because
that's true,
we don't know if the jury would have done it better if they choose Runkle's method or they choose my method. We don't know. We don't know which. We'll never know which method they were leaning toward and how it would have played out. So it's really just
you never
really
know how it would have played out in the alternative. You never know if I was right or Matt was right or Runkle's right. We never really know for sure. We're all taking guesses.
Mm-hmm.
Yeah. And it's just on intuition. You guys, I assume we're all expecting the directed verdict motion or the equivalent thereof in Wisconsin, right?
Yeah, we're all hoping beyond hope that the defense remembers that's a thing and formally makes the motion, because I'm not sure they technically have, even though the judge is already considering it. So I don't know about all that, but they better make it formally this morning. And
do they normally do these? I mean, here in Mississippi and then in Tennessee as well, we typically do directed verdict motions or the equivalents thereof after the state completes their case in chief.
Yeah,
Now,
there's
did
there's
they
that,
actually
and then you can also make it at the end of the entire case as well.
judgment notwithstanding a verdict? There you go.
Well,
Right.
at this point, it would be a judgment as a matter of law, I think. because
Judgment's a matter of law,
notwithstanding
that's right.
verdict doesn't come till the jury comes
That's
back.
right, because there's no verdict yet. That's right.
Yeah.
So we
But-
all were anticipating that they were going to bring that motion when they finished their case in chief. And
we've
what
been
yeah.
sorry, we've been
go ahead.
anticipating objections all the time too. So
Yeah,
who
yeah,
knows?
yeah.
It's hard to
That's what I'm
predict.
saying, man. This defense sucks.
And they do. The defense is terrible. To excuse that failure to move for a directed verdict, I think someone found Wisconsin law which says that if you move for a directed verdict and then you and it's denied,
Yeah.
you move forward with your case in chief, in that case you have no right to appeal it. I don't know why they couldn't move
Yeah,
for it
I
twice.
understand
Though.
that. I get
I
it,
don't know
though.
why couldn't they move for it twice.
No,
Like,
that
move
you
for-
That's
can.
what we
That
can do
makes
down
total-
here.
Yeah, no, you can move for it twice. That's exactly right. Like, so if you move for it at the end of the state's case and you lose and you put on your own case now, you can't go back and question that decision again. That makes total logical sense. But you can still at the end of your case, and now that's an appealable issue. Or you can when the jury comes back, and that's an appealable
weird.
issue. So it just moves in time when it is. And hello, Legal Bites. How are you this morning? They've
Hey.
been waiting for you.
Good. How are you? I know. I was getting caught up with coming up with merchandising ideas for Legal Mindset for his
Ooh.
bathroom set.
Oh, God.
Legal
You know,
Bites
some
merch.
premium-
I've been
some
resistant
premium
to
stuff.
going the merch route. So
Well, I figured it's only natural, right? I mean, he's right there in South Korea. He can get some
Oh, yeah.
premiums, bath.
that's right.
bath
You can just go to
soap.
the factory next door and ask. Yeah.
Exactly. Just wash away the mainstream media's BS. I mean, it's
No. Rub legal
Absolutely.
mindset all over your body. That's what you got to do. That's the soap ad for legal mindset.
Well, I wasn't thinking that route, but I mean, there you go. I guess there's a market for that too. They're probably, I mean, I've seen some of the chats, some of the people in the chat for legal mindset. So there could be some people that would be very interested in that as well.
Can I
Or
talk
just
about
the
something
bathroom
completely different
liquor
for a minute
caddy.
and bitch at Facebook and YouTube for taking away the dislike button? I know it's completely off topic, but I want to bitch about it.
Well, it's not
So we no
entirely
lo-
off topic, right? Because we're talking about the MSM.
Yeah. We're taking away the dislike button because of dislike bombs. Sure, it has nothing to do with the mainstream media's things being completely ratioed to hell, or YouTube React being ratioed to hell. It's to protect the small creators because YouTube is so well known for protecting the small creators. Don't you know? Okay, we can move back to Rittenhouse if you like. I just wanted to say something about it.
I want to do this. I don't know. Yesterday, I came to a realization about Judge Schrader and who he reminded me of.
Ooh.
Oh.
And,
This is gonna be bad.
Someone actually sent it over, and it's exactly correct. So here we go. There he is. There he is. That is it. I cannot shake the image of him being that turtle. Oh my goodness. What is this? What is this, Joe? What do you have here?
That was one of the things that was sent to me that made me start crying on my with laughter last night. That was somebody picked a good moment, yeah, and they really captured. I should point out that in the comments, someone basically pointed out that we have to change Runkle's names to Logolus. So
Yes, that's pretty good for a new channel name, Logolus.
Oh my gosh.
So I just thought I'd share that with you guys.
Yes, legal mindsets seems to be the most accurate, I think. So did you guys? Sorry, I had to step away for a minute. Did you guys talk about the that the state will be potentially at least telling us the lesser the lesser included list is what was alluded to yesterday, and they should have that finalized today.
What I want to point out, I think is, first of all, if they bring these motions, you're all on the same page with me that it's got to be like one by one charge on each of these on each of these murders, right? I mean, the charges are broken down that way, and I think that if you work backwards in time from what happened, there's an admission from Gage Grosskreutz that it was valid self-defense. That one I think is the easiest slam dunk to get a directed verdict on. You might not get on Rosenbaum, you might not get on Huber, but the assault on Gage Grosskreutz after he admits on the stand that that the gun was not fired until after he aimed his gun at Kyle, I think as a matter of law, that's one that the judge is most likely to grant. Right?
I agree.
Oh, what the?
I mean, because the other stuff, I mean, the video evidence could be wrong. I mean, in theory, you could disbelieve our eyes, and that's, I guess, if you disbelieve your eyes altogether, in that case, you can find a basis to deny a directed verdict on the first two, on the two murders. But I'm feeling confident that if they bring this motion, I feel more confident the motion will be granted than they'll actually bring the motion, because I don't believe in this defense at all. But I feel really confident if they move for a directed verdict with respect to the assault on Grosskreutz, that will be granted, because the guy made a blatant admission. You can't have anything easier for the judge to say that, hey, he admitted it, it's gone. So just throwing that out at you. As far as getting directed verdict, there are different levels as far as likelihood of success on these charges. It's not like everyone say, "Yay, Kyle won, case go home." That's not going to happen for the judge. If any, he'll break it down charge by charge, and incident by incident, and then try and address, okay, is there any way a reasonable jury can reach a conclusion that he can be found guilty beyond a reasonable doubt?
Yeah, I think there's the issue that I'm trying to divorce myself from the evidence a little bit, because I think we have to on the directed verdict, which is weird to say, but if this were a differently managed case, we have direct evidence of self-defense on all three charges. I mean, we have Gage Grosskreutz testifying against himself on his claim. We have him testifying pretty clearly against Anthony Huber, and he's a state witness on that claim, a complaining witness. And then we have Richie McGinnis testifying directly against Rosenbaum. And the only testimony we have that contradicts McGinnis's testimony about Rosenbaum reaching for the gun is the state's hypothetical that maybe he was slapping the gun away. And the only person to have testified to that is Krause. Krause, the state attorney, is the one who testified that maybe he was slapping it away. Here's the only testimony on the record is from McGinnis, and McGinnis said he's lunging for the gun, screaming "fuck you" and reaching for the gun, and that's confirmed by the medical examiner, who says that not only was the hand in close proximity, but the barrel had to be sufficiently past his pinky so that his hand is literally over the muzzle of the gun. And so it's like, I don't see how there is not reasonable doubt for every single murder charge in the record. And the only thing that there is a counter argument to that is the state lawyers arguing it. And that blows my mind that we're here because the state lawyers have created a scenario where they interject their own set of facts as facts. Their own narrative is fact. And
speaking of which, the very conclusion from their rebuttal, because I actually had a theory that I just divined 12 seconds ago, which is maybe the reason they were fighting so hard to get that picture, that pixelated, that modified, altered picture, which I still look at it right now. I can't understand if the parts that people are saying is Kyle, why isn't that picture? His shirt is darker than his pants. It doesn't make any sense to me. Anything about that picture, I don't understand it. But maybe now, if you're the state and you're trying to survive a motion for a directed verdict, you could say, jury, we'll look at that picture. It's possible. Look, and before your chat goes nuts, I think it's insane to think that any jury would come up with this. So I'm just saying this is what the state theoretically will try to argue is, you're saying there's no evidence that a jury could find. Well, a jury, from the state's perspective, if they trust us completely, which is how you're supposed to view this, that's the yardstick for this motion. If they trust us completely, they will look at that picture, realize that Kyle waved a gun at Zeminski, and that Kyle was charged by Rosenbaum in defense of others. He was trying to save Zeminski's life or some person behind his life. And based on that, he had no justification for pulling trigger on Kyle, and ergo, he can be found. They can reasonably find him guilty. That is what Little Binger will say. I think it's insane, but that doesn't mean that technically, as a matter of law, he's right that would create some sort of basis that a pretty unreasonable jury would come up with.
Yeah.
Go ahead. Sorry, Ron.
I was going to say the only other thing I can think of is that Rittenhouse is allowed to define his own priorities. And sometimes clients have different priorities than you might expect. He might be saying, listen, I want this to go to a jury because if it ends up getting thrown out by the judge, I may never be able to get a job again. I may never be able. But that seems crazy to me.
I don't believe that.
That's the kind of instruction you get in writing with this is against legal advice written in big letters across the top.
I mean, strictly speaking, in the United States, and I don't know how it is in Canada, but in the United States, that he can't make that decision. The decisions for the client are fairly limited. The decision on whether or not to plead guilty, whether or not to take the stand, whether or not to appeal, and there's one more that I'm missing. But the Supreme Court has ruled a couple times that the issues for the lawyer are the tactics of achieving the goal, and the goal cannot be defined overly specifically. So the goal is not guilty. So strictly speaking, a lawyer is required to file this motion even if the client doesn't want to, because the client has set the goal of not guilty. Great. What's the best means of me getting there? Filing the motion. And so not only would you not be unethical for filing it, you'd be unethical not to file it. You have to file it because the client can't constrict you in a criminal case that way. So, yeah.
That'd be a distinction, I think, here, because you can have clients who have different priorities.
Yeah.
The one thing about going back to the Rosenbaum shooting, because I think that is the muddiest at this point. I should say there is on the record evidence alleging Kyle raised his gun. That was actually said before the jury. It's on the record. But what they need to hammer out is that the state's evidence of that is a police officer who watched a grainy video on an iPhone, allegedly with pinch to zoom, that was not reviewed. Even if you say that the picture, is shown to the jury, what the police officer testified was not admitted into evidence, because he testified that when he pinched to zoom on an iPhone, he saw Kyle Rittenhouse raise his gun, which is in no way personal knowledge. And they need to hammer that home and try and get the Rosenbaum. To me, like getting that one on a directive verdict might be the most critical, because again, if you get a judge saying, we've dismissed that charge against Rosenbaum as self-defense, and then they go into the next two and they're like, oh, well, okay, that was self-defense. I mean, even if you somehow don't win on those, but that, like if I'm drafting that motion, I am focusing heavily on the fact that the state is attempting to contradict their own eyewitness with a non-eyewitness who allegedly reviewed a piece of evidence that was not ever reviewed by the jury. And that is it's just not acceptable for the state to use that argument. And they're going to on close tell the jury that you saw from the video, he raised his gun. He did it first. He'll use that patronizing tone, and I want to punch him in his little tiny dick. Oh, I hate that tone so much. Oh, God. Sorry, I have a personal issue.
Hopefully the jury hates it just as much.
Yeah. I mean, I think I've really thought about the directed verdict likelihood at this point. And I think after the judge allowed in that evidence yesterday, I thought it was pretty flimsy foundation for him to allow that in. But I think he probably would rather admit more evidence and allow the jury to just make up its mind, which tells me I think that he probably has a similar line of thinking for the overall case. He'd rather give it to the jury, let them decide, rather than taking it away from a jury and deciding himself.
I agree, and that's what annoys me because, again, the legal standard in this case, some of these are matter of law questions. They're matter of law questions. I forgot. The other line of argument that I would put into that motion is very clear. There is an eyewitness available, subpoenaed by the state, prevented from leaving the state by the court right now, that could have testified to whether or not Kyle Rittenhouse raised a gun at him, and that's Joshua Zeminski. And it wouldn't be a Fifth Amendment issue because there's no way him firing, well, it could be a Fifth Amendment issue, I guess, but he could be called by the state. Absolutely. They could call him right now and they could say, the only question they have to ask, did Kyle Rittenhouse point a gun at you? No? Okay, cool. Yes? Oh, really? Can you show us where? The state could have gotten that on the record. Can you show us on the video where his gun touched you? You could do that. They'd have no problem doing that. And that's what I would be arguing in my motion. Instead of bringing in a known eyewitness who's already under the state's watch, they brought in a detective who wasn't there to testify to a video that doesn't actually exist.
I think.
So just to clarify,
I was just saying, I think you might be wrong on that one because the cross-examination would be unlimited because either it's unlimited on its own terms or they can bring it up as their own direct witness either way. The problem is once he's on cross and they're asking him questions that would incriminate him, he won't answer those questions. Those questions are material. He won't answer them. So the only remedy is to strike his entire testimony in full. So therefore he can't testify to the one question either. So the whole thing's pointless.
Let him exercise his Fifth Amendment right.
But couldn't they grant it?
Not supposed to call someone with the
something?
knowledge they're going to do that. It's an ethical issue. But then again, with the ethical issues going on in this court, what am I talking about?
But he's not Matt bringing up a good point. He's not currently charged with illegal discharge of a firearm. He's charged with arson. So they could actually grant him immunity on the illegal discharge of the firearm.
Yes, they could. That would solve the problem if they wanted to.
And they're not going to prosecute him on it. Sorry, go ahead, legal.
I was going to say, to clarify, he is available, right? It's not like he's gone missing and like they can't bring him in. He's around.
Yeah.
I mean, if he had gone missing, they'd be looking for him right now.
Yeah, he'd be in violation of his release conditions.
Do you think that you have any confidence that Mark Richards is going to even mention the failure to bring Zeminski to stand? Because I have no confidence.
No,
Shirafisi might. He wrote some of the motion practice in pre-trial, so maybe he might. But I haven't. This is one of my big frustrations with the case. Wisconsin does not have an open system for retrieving documents, so I have not read their motions. I can't see how they write these briefs, and I can't get a feel for any of that.
You should write
you're getting all this wonderful super chat money. Sounds like you need to paying a clerk to make some copies, man.
Kick them out to us. Overnight them to us. We need to be able to review them also. Seriously.
Yeah, clerk, get on it. You got nothing else to do. I'm a very important YouTube lawyer.
They're going to charge you like 10 cents a page. You'll be great.
Oh, God. I do need to, speaking of super chats, by the way, guys, I think this is actually going to start in about 38 minutes. The PBS NewsHour said it was starting at 9. It's waiting. Law and Crime actually says it's starting at 10. These are Central Time times. So I think we've got about 38 minutes till the actual proceedings start. The judge must have been like, let's take a little bit of an hour leisure here. But speaking of super chats, the Dragon's Treasure says YouTube is censoring a real message. Text sent to Twitter DM. Feel free to read when you deem appropriate. Well, I know that Dragon's Treasure will never send an appropriate super chat, but let me read it real quick here. He says, hello, humble anime-themed tea peddler here. Been a supporter of Mr. Ricada for a few years. Oh, I see why they wouldn't accept this. This is long. for a few years now, and he has treated me too kind. He's given good graces to let me grift during his historic event. I make and sell anime-themed loose leaf tees and tea accessories, vouched by me, Nick, himself for being good, and maybe by some people on the current panel. Visit thedragonstreasure.com and use the appropriate coupon code 4 doors more whores on the website to get 10% off your next order. And part of every sale will be fed back to the Ricada family.
Nice.
He also
Nice,
has an
Kurt.
anime. He has an
I'm
anime.
gonna help pimp here.
Yeah.
But
A dragon's
in all
treasure.
honesty,
Nice.
the Dragon's Treasure, he does have very good tea. Does he not, Kurt?
Yes. Yes, he does have some wonderful tea and some wonderful flavors. For example, this one, Phoenix Ash, or this one, that's also wonderful, Earl Grey tea with vanilla cream. That's been very exciting in my life.
I like
you can
Elixir of the Gods.
You can go to the Dragon's Treasure and get some wonderful, wonderful teas, such as this Gryffindor Common Room tea that I've been
Ooh.
enjoying. So go to the Dragon's Treasure today. Get your tea-related needs. It's awesome.
The
Yeah,
head
it's-
models on The Price is Right are jealous today.
Yeah, it's actually very good tea. And he did ask if he could send a super chat, and I said, of course you can, because
I was an adventurer like you until I was shot in the knee.
Rosenbaum said almost the same thing.
Oh, no.
Cute.
But yes, it's good. It's very good tea. It's hand peeled. What do you do with tea? Because
You
hand.
seep it.
steep
Well, I
it.
don't know. Yeah.
No, I know how
Yeah.
you make it.
How
I
do you
mean,
grow
how
it?
do you?
No,
Is
you
it
grow it.
is it
steep
hand
you steep-
picked?
Oh.
I know how you. Again, I know
I
how
make
you
it into a
tea.
really fine powder and I just snort it right up into my nose. It's great.
You guys are on the you consumers. I'm talking about how do you advertise that you hand picked tea or whatever, hand selected, hand blended, you don't craft it, right? You're not making the tea. You got to
Crafted
grow
works
it
for
on.
me.
I don't want my
Handcrafted, that
tea going
works.
through someone's hands. I don't know. Everyone made a big thing about hand-picked, roasted coffee. Why do I want some guy touching my coffee bean?
There
Because
is a guy touching your coffee beans.
I know, but that's not what I want to think about. It's like, this is why I want to buy it, because some dude down in Central America had his sweaty hands.
Oh
all
my
over
gosh!
this thing.
listen to this racism.
This
That's
is a
not
good one. This
racism.
Tai
I'm
Chi.
assuming it's
This is
a very
really nice.
white person down in Central America has scrubby, sweaty hands. All
You know,
over
you
my
could
coffee.
disinfect those coffee beans by perhaps applying
Smell the
boiling water
sweat.
to them.
Yeah, what Joe would rather have this industrial machine grind up his tea with all
I'm
sorts
simply
of
saying.
industrial lubricants and shoved
don't
into
wanna
a
think-
dirty piece of cheesecloth that's been sitting in a factory floor, or maybe sitting on a boat off the coast. Did you guys see?
I'm sorry. So that's how they advertise coffee. You go when you go into your favorite steakhouse, they show you a cow laying there on the ground. Like here's
If
an
I'm
image
going
of a
to my
cow
favorite
sliced-
steakhouse, yes, they do.
In
That's right.
Hitchhiker's Guide to the Galaxy, the cow comes up to you and says, "What part do you want?"
That was it was on The Simpsons when they went to that the meat restaurant where the menus were written on pounded out chickens. And Mr. Burns goes up and you got to kill the cow. They killed the cow right there in front of you that you got your steak from. He's like, that one. Oh, he was a little weak. How about that one? Not much of a fight there. How about that one? Oh, I'll have a salad. Oh God, that was back when The Simpsons was funny. But did you guys see last night? It happened. I called it. I said it would happen.
Yeah.
And some of the first articles to come out were the judge making an inappropriate Asian joke about lunch.
Oh yeah.
And of course, they get statements from all kinds of people from different Asian groups saying like, "Oh, this just goes to show that racism still exists. It's very much alive, and stereotypes and all this kind of stuff." Meanwhile,
it's a shipping joke.
It was a
right,
shipping
It's
joke.
a shipping joke.
right,
Clearly.
right. Long Beach Harbor is a shipping port. I mean, there are some cruise ships, like 2, I've seen them because I used to work in a building that literally overlooked the harbor, and I would look directly at these cruise ships. But by and large, it's a shipping port. You have tons and tons of ships carrying cargo coming through there.
They're not coming through there right now, to be fair. They're just sitting outside of it.
That's fair. That's fair. That's fair.
I'm surprised.
And the only way that there's any form of immigration going through there is human trafficking, which is not legal. So yeah, I don't think that was his point.
I'm surprised they didn't construe it as an anti-Biden joke after the Lee Greenwood ringtone, right? Like he's clearly talking about the Biden administration here. Very inappropriate.
Yeah, he's definitely that's like Trump's theme song or something that people were saying. Meanwhile, that song has been around for so much longer.
It's been around since '84.
Yeah.
No, I saw one article declared it the national anthem of MAGA. That was a nice touch.
Let's
I'm
see.
not sure if there was a vote or something, but yeah, okay.
Let's see. Let's get to Billy Witch Doctor 99 says at this point Ronnie O'Neill would be a better defense attorney for Kyle. Thanks again for covering this rackets. Danger. Actually, could you imagine if Ronnie O'Neill were defending himself against Binger and Krause? I think Binger would have crapped his pants. Like the Florida lawyer who sat there as Ronnie O'Neill was like staring him down like he was going to murder him and get charged again. He didn't seem to care, but I think Binger would have maybe folded under that pressure. I think Ronnie would do a good job. Danger UXO says you should get Colion Noir on to talk ballistics. His video bashing Binger on hollow points is great. And to that point, I've gotten a bunch of DMs. I'm sure you guys have gotten a bunch of DMs about this, where it's like, you need to read this on digital imaging because Binger's wrong. You need to read this about whatever because Binger's wrong. It's like, no, we know. We know the person who needs to read it is Richards or Sharafisi. They're the ones who need to read these sources and take them into court and say, Your Honor, even Wikipedia knows this guy's lying. Even Wikipedia.
One thing I need to throw out there, because I don't think we mentioned on our stream, I had 1,000 people. Okay, that's an exaggeration. Countless people yelling at me to raise this point about the picture, and I can't even see him in the picture. I'm not making a joke. I don't know which part is supposed to be Rittenhouse when I look at the whole picture as a whole. But apparently in the picture, people believe that he's holding the gun with his left hand, whis he's right-handed. That's
what Posobiec tweeted out, and I get what he's saying, but even in the picture blown up on his tweet, I can't make it out either. I could pull it up. Maybe we should do that real quick. I'll pull it up.
How far? I mean, from the standpoint of the camera to where Kyle was, I mean, how many feet, how many yards do you think that was?
No.
All of them.
From the camera to where where Rittenhouse was? I mean, what? At least 100.
I couldn't see him. Well, the reason I'm asking that question is that, they talked about averaging the pixels or whatnot. And, if I'm standing 100 yards away and you're looking at me and you've got my bald head on the top and my whatever color shoes I'm wearing on the bottom, and you try to do an average of that, I mean, that might create a color or an image that's completely different than what's my gut. I mean, that to me is the most bizarre thing about this whole this whole pixelization issue. It's one thing if the fella is, 50 feet in front of you or 5 feet in front of you, but when you're talking 100 yards or even maybe half a mile, my goodness gracious.
And the whole thing is like, it might not be a big deal. It might not be a big deal. It's just that the expert didn't have any clue what they're talking about. I have no idea how these algorithms work. I have no idea how it adds this information.
I think I see what Posobiec is saying, and wait, let me pull up. Oh my gosh, I got to open it in a new tab so I can further zoom in and ruin the image.
Oh yes, please let us look at these images because I can't see shit in them.
Yeah.
So.
All right, here we go. So here's the image. The original's on the right and the blown up one is on the left. The first problem that we have that I noticed is you notice his strap here, right? Seems to end in the image about halfway down his body. And over here, there's clearly more black on this image than that one. So that's a problem. But what Posobiec is saying is that he became left-handed, pointing it at Zeminski, which
direction is Kyle facing?
I can't even tell.
I don't see where the gun is even.
Where's
he should be in theory, he should be facing towards the camera, because from the perspective of where the camera is and the timeline of events, Kyle should be here. Zeminski, I think, should be over here. No, he's got to be over here, because Kyle runs this way towards into the car source lot. Rosenbaum comes from back here.
Oh, that's right, because that was the car he was hiding behind, or whatever.
Oh, so this is
that he stopped behind.
This is right when he was running before he enters the lot.
It's before so he has just come in from the street, put out the car fire apparently, and dropped the fire extinguisher, which I guess they're saying this lit up blob is the fire extinguisher. I don't know. It's not
But
clear.
That doesn't even appear in the other image. You know, that little white blob, like there's nothing there. And then suddenly it appears over there.
And again, that's why the introduction of this photo evidence should never have been allowed.
The guy on the white, look, his stance looks completely different.
It's actually, that's another thing that Posobiec pointed out, is that the motion on here is the motion lines are different for these people. Because the image, look at how it's changed the blurriness of the original and actually sharpened it up while enlarging. That doesn't make sense.
We've gone from our hands down our side to like in a just straight up side by side pose. I can't tell anything from this photo. I see no things.
Yeah, the street sign, of course, has significant distortion and artifacting versus the original. Like again, maybe it's not a big deal, because if the jury looks at this thing and they see the same thing that we're seeing, but you never want to leave it to the jury to recognize what's obvious, because they might not.
Yeah.
I think from the judge's perspective, though, I think when it comes to making out what the picture says or what the picture looks like, that's probably something that he figures is more for the fact finder at the end of the day.
You know, I kept hitting on this yesterday, and I will not let this go. And I think it's reversible error. It is. Tell me if any of you have ever heard of a picture or any imagery ever being emitted without there being testimony that it fairly and accurately depicts what it purports to portray.
No, I definitely agree. No. I don't think that they
no one
testified
to that. They couldn't testify to that. And to me, that's reversible. Letting this in is reversible error. If he wants to let in whatever he wants to let in, and even if you want to qualify the most unexpert expert in the history of trials, who's the only expert I've ever heard, which every answer to any question is, I don't know. Well, what happens with this? I don't know. How does it do this? I don't know. I hit click and it blows it up for me. I mean,
did you check the results next to each other? Did you check the final picture next to the original picture? No, I didn't do that. Wait, what?
Exactly. So we have zero basis to believe that this fairly and accurately depicts what it's purporting to portray. That is evidence law 101 inadmissible. That's reversible error if they convict.
Yeah. I almost wonder, do you guys think that it would have been helpful if Sheriff Easy had actually brought up these two images next to each other in front of the expert, non-expert witness, and actually pointed out these differences and said, explain how this shows up, explain how this little white blob down here by Kyle's foot shows up in the left image, but you don't see it in the original image. What is that? What's happening here? How is that not more information that has been added that didn't exist in the prior one? Explain that to me.
Explain how this light becomes this rectangle of light. Explain that to me, sir.
Yeah.
Explain how this Yeti, right, becomes a blurry murder dog. I don't know what these two images even are. Like we can't down here suddenly. Look at this. Oh, here's my favorite. This person. Show me where this person exists in the original image.
Oh yeah.
Like where'd they go? Where are they? Oh, they're cropped out, I guess, of the bottom. So this is a bigger image. So again, these two things are not the same, because this would have to be cut off about here, and it's still not the same. But
I feel embarrassed to offer this as an exhibit on every possible level.
Unless,
Well, I
I mean,
mean-
well, let's just, I just want to make sure that we're clear. Are we sure that the original one is the one on the right and not the one on the left?
I was just going to say, no, I don't know.
Because it would make sense to me if the one on the left is the original and the one on the right is
In
the
which
one that
case we're
crops
losing
out everything
detail.
else.
In which case we're losing detail because the thing that's on the curb
Yeah.
no longer exists. So take your
Yeah.
pick.
Right.
Yeah, the thing that's on the curb no longer exists. The sign is suddenly got details that were not present before. The streak or the light reflection on the car is different. I think they're actually different frames. Personally,
That makes sense. And I'll tell you why. Because if you look at the woman to his right, she looks like she's more turned towards the camera on the picture on the left, and more
Yeah.
sideways in the picture on the right.
and her shiny shield of radiant brilliance has
I think it's
changed
two
complete
different.
directions.
I think it's like 3 milliseconds apart from each other or something. 0.03 milliseconds
Yeah.
apart, and their
Yeah.
motion, and that's why it's turned.
They're different photos. That's just the greatest news ever.
That's what I believe makes the most sense. This is different. That would explain the whole angles line, which honestly, when Posobiec points those angles, I don't know what the green lines are supposed to mean there either.
On the
I don't
left
understand.
behind the
it's-
truck, I've got two blurry things that could be people or canisters
Or a
something.
fence.
And then on the right one, I've only got one of the blurry things.
Yeah,
Yeah,
I think these are two different pictures.
That this was allowed to be admitted into evidence is in my opinion, the worst decision that the judge has made in the case.
Yeah, no, there's a lot of bad decisions. This is
Okay, I'm curious what decision you would say that rivals this one from other than not declaring a mistrial, maybe.
allowing
But,
the legal charge of the illegal possession to go to jury is
Oh, yeah.
up there.
Yeah, that's true. That's true. But this one is, I mean, this is evidence. This is on a murder charge. Like, this is being used as evidence on a murder charge.
To put
and
him away for
upon
30
inspection-
years. To put him away for 30 years over this random pixelation. This randomly adding in different color pixels. That's what they're potentially gonna put him away for 30 years to life on. It's
Yeah.
insanity. It's insanity. This poor 17-year-old kid. His life should be hanging in the balance because someone decided they're gonna pull out a crayon and just start photoshopping and whatever pictures are happening in there. And if it's not an individual manipulating intentionally, then it's a computer that's manipulating and trying to guess what pixels should go in there.
And it's really important to note that Binger's argument is that, yeah, we all use zoom and cropping on our phones. Got it. And Shirfisi pointed out correctly, we're not using those pictures in a murder investigation, or well, he said a homicide investigation. That's not what they're being used for. And if your life is on the line, you have to have these things thrown out. It's so unfair to the defendant who has the presumption of innocence, who has all of these rights to confront their accusers. What accuser is he confronting here? A detective who looked at a video and interpreted it in a particular way? Almost none of the evidence in this trial should actually be there. None of the video should actually be in there. But Richards and Shirfisi, they stipulated authenticity, so then it gets to come in. And the question is, I guess, how much of dicks do you want to be on that? But I don't know, man. They've let in a lot of evidence that has no foundation.
Also, one other thing, kind of on a slightly different subject, but I was reviewing the part of when Drew Hernandez was on the stand and getting into the line of questioning about him hiring an attorney. I actually, I was a little tired yesterday. I hadn't yet caught up on sleep yet from the night before. But I guess I wasn't paying as close attention, but I think if I remember quickly from reviewing the video that the judge actually snapped at Binger in front of the jury. I think that may have been the first time that he did that, because when he got the objection for relevance, and then Binger started to justify, like, well, there have been a lot of questions about people hiring attorneys, and then he was like, what's the relevance? He actually snapped at him, and I think only after that he let the jury out. I thought that was interesting.
Yeah, the other questionable decision of Schrader yesterday, and this one goes the other way, is his Veterans Day remark.
Yeah.
Like,
Yeah.
he's got John Black up there on the witness stand, sitting down, as he does. He has a very professional court demeanor, which is great. And he's sitting there at the witness stand. The jury is in the room, and he says, "Oh, speaking of which, it's Veterans Day. Do we have anyone who's served in here? Anyone on the jury?" And then anybody over here? And John Black, stands up. And I got the impression that he may have been the only veteran in the entire room. And
then he goes and he talks about like not just being a veteran, but like being a Green Beret, being like a lot of he's got a very impressive resume, 30 years in the military. And
23 in law enforcement. I mean, the guy's been doing his job, but
no, I definitely agree. Like he could have Judge Schroeder also could have remarked that it's Veterans Day, Happy Veterans Day, kind of like made like a note of appreciation for everyone that has served without like specifically identifying who in there has served. But
if they had done that in the opposite way, that would go in your motion.
There was a real risk there that one of the jurors was a veteran. I don't know the degree to which they vetted that out or not, but if there was one veteran in there, and then those people might, just having been applauded, might now suddenly have undue influence in the jury room.
Yeah.
So that would taint the jury, and that would be another reason to appeal. So fine.
Although, I mean, within the jury room, I mean, someone could easily speak up and say, "Hey, I served for 5 or 10 years or whatever, and I know guns," and what they're saying.
It probably doesn't help being primed. It doesn't probably be helped with reams of applause by the judge. Yeah.
Yeah, it's like I said, I don't think it matters as much because he was a defense witness. And I don't really care if the state is prejudiced personally. You could not find a lower thing on my list of court reforms that need to be fixed rather than the state being prejudiced by a minuscule amount. But if it was the other way around, I think it would matter a lot more. Lindsay B says, if Kyle is acquitted and Littlebinger wants to retry him, can the DA decline to take it back to court or order Binger not to as well? Well, Binger wouldn't have the decision at all. The DA would have the decision to retry Kyle.
Right.
Binger could maybe recommend it, but the DA has the thing. But if he's acquitted, let's be clear, if he's being precise on legal language, if he's acquitted, they can't bring the charges back.
Because that is double jeopardy.
Yeah, it would only be in the case of a mistrial from a hung jury or a mistrial that's dismissed without prejudice by the judge. One of those two instances where they get another bite at the apple, I learned was the correct phrase yesterday. Raymond Fire says, I'm confused on this case. I have heard that this is an easy not guilty verdict. Well, under the law, yes. He says, yet it also seems that you guys think that Kyle would get found guilty. From what I can see is if he is found guilty, self-defense in this country is gone. Does anyone want to comment on that?
Well, for me, I think that the risk of him being found not guilty comes from what the jury has seen of the evidence and what the jury, what kind of biases they have beforehand. I mean, because, as I have, like, if I were a member of the jury, I know how I think about this evidence as I have seen, as I've been able to analyze it. But I've been able to pay attention to whatever extent, and I don't know what the circumstances are for each individual juror. I like the fact that they are allowed to take notes, though. Not every court allows that, by the way.
No, they don't.
Yeah, it's up to the judge's discretion in Wisconsin in the criminal procedure rules.
Yeah, and I love that because I think that not only does it help for recall, because when you're getting hit with so much information, you can very easily forget something, and it also helps you to pay attention more. But yeah, I mean that's basically that's my thoughts on how he could end up guilty.
Let me ask y'all this. I mean, I think from what I've seen in the news reports or what I've gleaned is that the whole argument that the prosecution, or maybe not so much the prosecution, but the supporters of the prosecution are making, is that because he brought his AR-15 to the car source and all the other places, that he was provoking others. And therefore, if he's provoking others, their argument is that, anybody else bringing their gun up, in effect, was acting in self-defense from him, and therefore him shooting these people could not be self-defense. How do you think that would fly with the jury up there? I mean, in the sense of, from a political standpoint, from just the pressures that you see in the news, and I know they're not watching the news, or at least they're not supposed to, but of course, how could you not know anything about this case when you're being voir dired?
I mean,
From
it's-
oh, go ahead.
Oh, I was just going to say, I can't see how that could possibly be the law, although I'm not a Wisconsin lawyer. But, I mean, juries do weird things. Juries will sometimes convict because they say, I thought he looked shifty.
Yeah.
You know, the prosecution had a real bad case, but he wouldn't look me in the eye, so I wanted to convict, is basically a quote from a jury interview on one case. You know, you never really know. So whenever something is going to a jury, sure, I think a reasonable jury should acquit this guy, but you know, you don't know if your jury's reasonable or if they're going to do something like, oh, well, you know, the prosecution guy had a nicer suit, so we decided we were going to convict. That's
I've also heard of a jury looking at a photo of a crime scene and looking at, in the very top corner, there's some sort of piece of what they think is evidence that was not admitted at evidence, you know, at trial, wasn't not evidence at all, but they saw it in there, and they somehow, for some reason, attached some kind of significance to it and just went down a complete rabbit hole that had nothing to do with anything that anyone was talking about at trial. So I've heard of that kind of stuff happening too. So I completely agree. They're wild.
Regardless of what the law of self-defense is, I mean, I think there is a risk that you might have some juror sitting there thinking, well, I mean, Rittenhouse shouldn't have brought his AR-15 to town, and if he hadn't have brought his AR-15 to town, you know, nobody would have been coming after him. I'm not saying that is or isn't a valid, reasonable argument, but I think that's something that any jury, and I think that's something that Richards and the defense team have got to really be concerned about, because
well, that's the whole theory of the case for the left.
Yeah,
that's the only theory of the case.
Yeah,
that's actually where they should spend a lot of their closing argument, in my opinion, since they have 2.5 hours of closing argument. They can do a 30-minute course on the fact that merely having a gun out is not sufficient provocation to justify someone attacking you. And in fact, there are several people, including Gage Grosskreutz, who had a gun present at that event that night. There is in Wisconsin, you can open carry. You know this. You have seen guns out on the streets of Kenosha, and no one is randomly attacking those people. That doesn't happen. That is not sufficient to go after, to attack someone. It is not provocation under the law. It is not provocation in common sense. They need to focus on that.
The prosecutor was also advancing sort of as a provocation thing. You knew that putting out those fires would make them angry. You knew that cleaning up that graffiti would make them angry. And I'm just like, if
that was a weird line of argument.
If stopping the city from being on fire is provocation that allows people to attack you, and you're just required to, at that point, sit there and die, like, is that really
setting the fires is a provocation?
It's the same kind of logic as, you know, you're wearing that dress and that's gonna cause somebody to come up and grape you, right? You know, like it's the same exact logic, and no one would accept that today, especially not people coming from, you know, the people that tend to be on the side of Kyle Rittenhouse being guilty tend to not allow that kind of line of reasoning, which I agree on any subject.
That
not
should
appropriate.
That should be the opening statement, right? Ladies and gentlemen of the jury, imagine, if you will, a young lady, girl, woman, I don't know the term. She's out there.
Female.
She goes to a bar. She's wearing a skirt, and that skirt's a little short, on the shorter side, and she's in a bar with a lot of men, and then they rape her and said she deserved it because the skirt was too enticing, and that now the skirt is AR-15.
Yeah,
Rosenbaum is
I don't know about
that
that
is
one.
what the defense needs to do in their opening.
I'm not sure about that one.
I spent a half hour
I think that there's been enough hard R in this trial without.
No, I spent a half hour on this analogy, and I'll take it one step further. Here's the thing: if you really think about that analogy, which we're standing up for the right that a person can wear whatever they want, whether it's a short skirt, or whether it's an AR-15, and that does not entitle someone to feel so triggered that they have a right to attack that person, and then we're going to blame the person who's donning the dress or the AR-15 and say you have no longer have a right to defend yourself. And if you defend yourself and hurt this person who was triggered by what you had on you, in that case, you could be guilty of murder. And if anything, the woman in the skirt, and I still 100% think it's unjustifiable for any man to attack a woman, and you're a sick individual if you do.
Yeah.
But what I'm saying is, if
I would
anything, the
agree.
woman is trying, she genuinely, we know for sure, is trying to allure men. And even though we know she's trying to allure men,
women,
I say anyone, okay, whatever. But she's trying to allure people with her sexuality and create a hunger, to trigger a hunger in them. Now, I don't think most rapists are triggered by natural sexual hunger. I think they have other crazy, ridiculous
desire
issues.
for power and stuff like that.
Right. And insecurities and all those other things they're trying to overcompensate for. But on some level or another, there is a certain sexuality, and they are trying to put out their goal is trying to put out this sexuality. And so all the more so when I say a woman has every right, and not only may, but must and should and must defend herself from a would-be attacker, and with lethal force if necessary. And the left has been screaming about this
according
for decades.
According to the prosecutor, not if the guy has only kind of has it out but not pointed in your direction yet. And,
hey,
and if he's got a smaller gun than you,
Well, I have a question.
Small. Yeah, nice.
I have a question. How many women are on this jury? Do we know?
It's 11 and 9, or it was when it started.
11 women?
It was 11 women, 9 men when they started it.
One of each has been dismissed, but we don't know how many are actually on the jury. We don't know the actual jurors.
They haven't drawn them lots yet.
You got at least 5 women there.
Because that
makes a powerful argument.
I could see a lot of women sort of subconsciously sort of thinking of that logic during this trial, as Binger is kind of putting forward that argument to be like, well, wait a minute, if I go into a bar and I'm wearing something that I'm wearing because I like it, it happens to be attractive, and okay, that's fine, but I like the way that I look in this dress, and that is 100% why I'm wearing this. Like this sort of logic, anyway. So I wouldn't be surprised if they would independently be a little bit more
streets of Kenosha.
Even if you don't want to get into this, like if you look at Top Gear, had that episode where they're driving around a car painted with slogans designed to offend people, and that's free expression, that's free speech. You could drive around, just saying, hey, you knew this was a really conservative town that you're driving around in a truck with "man love" painted on the side.
Man
that
love
doesn't
rules
mean that
okay.
it's provocation, and now you should lose self-defense. That's
Joe, there's one other thought that crossed my mind. You were saying, because I'm going to take this and take your argument and take it even a step further, because I don't know if anybody's ever raised this, but a few years ago I had a case where a guy was charged with the possession of a gun while he was in a drugs, stop for drugs or whatnot. And in my motion to suppress, I pointed out that because he was between the age of 17 and the age of 45, and he was a male, under federal law, he was a part of the unorganized militia of the United States, pursuant to, here's the statute, got it right here.
The Militia Act of 1792, I think.
Yeah, Title 10, U.S. Code, Section 246. And of course, the DA thought that was hilarious, but then he gave me a deal. Point is, I'm wondering if Richards and them have raised that, if it would be too late for either of them to bring it up.
No. I don't want to go there. No.
Wait. So
explain what you're trying to say there.
I'll read the statute to you. The statute says here, subsection A, the militia of the United States, this is federal law, Title 10, Section 246. The militia of the United States consists of all able-bodied males at least 17 years of age, and I believe he was 17 when this happened. Mm-hmm. And except as provided in Section 313 of Title 32, under 45 years of age, who are or who have made a declaration of intention to become citizens of the United States and female citizens of the United States who are members of the National Guard. And so essentially, if you're a guy between the ages of 17 and 45, you are automatically a part of the militia of the United States under federal law. And I think if he had wanted to make that argument in a legal motion or something, he'd probably say, look, I'm the militia of the United States. I have the right to have a gun there whenever there's insurrection happening.
I don't know if it's in their legal brief, but it was actually raised at oral argument in the unlawful possession portion that 17-year-olds are part of the national militia, and that they use that as sort of instructive on why there's an exception for 16 and 17-year-olds. Or, well, they didn't say 16 and 17-year-olds. They just said 17-year-olds. Why there would be an exception for 17-year-olds built into the unlawful possession of a firearm charge is that they would be members of the national militia. It didn't seem very persuasive to the judge. I don't know if they briefed it other than just it was raised in a very short bit of oral argument at pre-trial, I believe. I was either at pre-trial or it was done briefly during trial, but like before trial started that day. I can't remember. There's a lot that has happened. And to the chat, we are just waiting on the live stream to start. It is now 10 o'clock Central Time, and it should be starting up any moment. So I have it on the background here.
I want to ask you guys, when did they ask Gage why he brought a gun to this thing? Do you remember him crossing?
Yes.
Crossing with that?
Yeah, he said because he believes in the Second Amendment.
Is that what he said?
Yeah.
No, seriously.
Yes. I'm not joking.
So, I mean, the whole thought is, why should he be bringing a weapon to this thing? And there were tons of protesters there. I mean, Binger was on cross, was drilling him. Like, why bring it? Unless you think there's going to be a problem, unless you think you're creating a problem, unless you think there's going to be a problem, why are you bringing it? And the obvious response on argument is, why did anyone bring it? Zeminski had guns there. Lots of these protesters had guns there. These rioters, looters, arsonists, they all have guns there. Why are any of them bringing it? Are they expecting that there's going to be trouble? It doesn't make any sense, especially if no one else showed up from the other side. Why are they bringing it? You're going into a situation where you have people who have guns, and there's a lot of emotion, a lot of hostility. He's got to be crazy not to bring a gun.
Well, and the other thing is that they never actually apply this to the other side. Like, what was Rosenbaum doing there? The guy who's dropping the hard R is probably not a big Black Lives Matter activist. You know, yeah. I kind of feel like that's an inconsistency as to what he's doing there. So if we're saying, why is Kyle there? Kyle's got a good reason. He's trying to, sort of support the community. But why is Rosenbaum there? Well,
I think he
wants to set some fires.
I think they completely flubbed the Rosenbaum girlfriend cross-exam. I mean, I know they got out of there that he's bipolar, or that she thinks he's bipolar, and that's why he was taking his particular meds. Great. Why didn't he stay at your house? Why didn't he stay at your house? Oh, he couldn't. Why couldn't he stay at your house? Like, because he's your boyfriend, right? He's just coming out of the hospital. Certainly, he needs a place to sleep that night. Was he going to come back to your house? I mean,
she could have said, I didn't have room. She could have made up any BS excuse for that.
Yeah, but that's not what she's planning on saying, because the state had said outside of the realm of the jury that she was going to, or that he couldn't stay there. And
no, I understand that, but she could have made up 1,000 other excuses besides the legality of it if she was looking.
I know, but let the judge get it in their mind that the state knows the answer and that their witness lied and that she was probably coached to it. To me, ask the question. That's one of the most frustrating things. Is ask the questions, because if you get to the hospital, if you get to the mental hospital, if you get to the restraining order, if you then get to ask, did you know about his? Was this a surprise to you? When you were in this domestic violence situation, has he been violent at other times that you're aware of? Like, you just start going back down the road, because maybe you get all the way to the fact that he raped children. And I mean, that's the prejudice you want. You want to know that this guy's got a history and propensity for violence. And if you can get there through the witness that they've given you for no reason other than to talk about how he was a good boy who brought an empty water bottle to the protest. Like, just drill it. And they should have let Huber's great aunt or whatever testify to how he was a good boy and he ran towards the fire that
was
he
a mistake.
probably even.
That was a mistake.
Because if they would have let that question go, they could have said, was that the fire that he set? Did he set that fire? Because he
But
was
then
charged
she wasn't
for.
there, so she wouldn't know. She wouldn't be able to answer that question.
Did you know that he set fires in the past? That's right. So once she answers that question, Judge, can we approach and talk outside of the jury? I'd like to propose a line of questioning, and then just hammer it home. Those two were big flops.
Yeah, I think that with those two, I'm wondering if the strategy there was to not go too hard on them because of the fact that they're both grieving, and that usually doesn't play well with the jury. So
Okay,
that's a justifiable thing.
And there probably was. They probably figured that there's enough evidence in these videos and in the testimony from people that were actually there to show that they were being violent. So you don't really need the propensity. So you don't need to dirty your own hands by knocking on an 85-year-old great aunt.
This is why we have a woman's perspective here, because
I don't know.
she gives us
Bury him.
What? You sexist,
Here we go.
misogynistic.
I mean, I don't know that we're going.
By the way, I can be here for about another hour, and then I'll be on Eric Hunley's channel, just so you guys know.
Oh, really?
Sweet.
Yeah,
Well, tell Eric I say hi.
I will.
Maybe I can be on both
poor
streams
guy.
at once.
He's
Is
been
that
on
a
the
thing?
sidelines this whole week.
Who else is going to be on Eric's channel? Do you know?
It's me and Emily D. Baker.
All right, maybe I'll pop over there for a while.
He sent me a link also.
Tell Eric to send me a link if he hasn't already.
Okay.
Tell him I'm very
or
offended that he didn't invite
DM
me.
him.
Okay, yeah, we'll do.
Yeah, Bricady, you want to go? You want to go join on?
Yeah. Britt Cormeyer says we all use Zoom on our phones and know how it works. That is like saying we all have driven cars, so we know how the internal combustion engine works.
Yeah.
Yeah, or the GPS. I mean,
Ooh, I can explain how GPS works.
oh, please don't. I took that math class. David Stern says you can take the victim blaming analogy one further. If a 17-year-old girl attends a concert that's 18 plus, she should not have been there. Same as Kyle accusation, and she is assaulted. Is she at fault for being somewhere she shouldn't be? Of course, it's not her fault. That's good. That's good.
a great
right
example.
there.
That's a great example.
Yeah. I mean, just this whole idea.
Hit the
he
Me
shouldn't
Too
have been
people
there.
Hit the Me Too people in the crotch.
Well, no, don't do that. If you hit the Me Too people in the crotch, you're getting charged. You don't want to do that. It's very unsafe.
I see what you did there.
Very unsafe.
Is he looking through a written motion? Maybe that'd be cool.
He's reading something, some concern maybe someone has. Did you guys happen to see the interview with Gage Groskowitz on Good Morning America?
I haven't seen it. I've seen people have they've tweeted me with it, but I haven't actually taken the time to sit down and look at it.
45 seconds in before I felt like retching, and I was just when he was talking about the fake testimony from Kyle, I was like, "F you, you freaking ham actor, terrible!" Like
The guy who admits lying in about the first 2 minutes of his cross.
The jury's not here, and we're here to talk about instructions and verdicts. And the district attorney has.
And to the chat telling me all about the images. We know. I got it.
We got it. We covered it.
Multitude of lesser included offenses.
But we appreciate your enthusiasm.
Oh man, he is the turtle. How I
Yes.
can't unsee it.
Especially with that tall chair behind him. It kind of like looks like a shell.
I'm looking at their. Sorry.
Oh, and what's the pin today? How's
He doesn't have one on.
So
No jury.
And no flashy
I
suit
have
today.
count
Just
one,
sports
just
coat.
the first degree. I'm sorry, the first degree reckless homicide. I didn't see any lesser included on that.
They asked for 10-20. Did you get the written request for instructions?
I did.
They asked for 1022. Oh, yeah, there was an email last night. Did you get that?
I did.
Okay, they asked for 1022, which is not the standard for first degree reckless homicide. It's the standard for first degree with a lesser included of second.
Okay.
Okay.
We're not asking for that, but I understand the court might give it.
Okay. Are you objecting to its giving?
Yes.
I want to discuss it briefly, or just impose or argue, object for the record.
I guess I would just object for the record.
Okay. All right, then. I'm not going to decide right now because I just got your filing this morning, which was sent to the clerk in Kenosha. They sent them to me directly. And I know you're not familiar with that procedure. So,
Okay.
And actually, I wish less people had my email right now. But I think that's probably a common feeling.
He amuses himself.
I will. What I plan to do is to send at some point tomorrow. I will send you what I expect to deliver as the final instructions and verdicts, and I would just now, given the evidence, I'll leave it. I'll leave it at that. And then we probably will have what I hope will be a brief discussion on Monday about it, and at least you'll have.
When there's no jury present, the judges are even less performative. They take a lot of time. I have a feeling we're going to have some lag time today.
Well, you can get through some super chats a little easier.
Fair.
Yeah, I've got to figure out how to do all these that have come in over the past couple days. I think I'm going to be doing a marathon weekend stream at some point.
The funny part is you'll get more as you do that, and then it'll just be like just living a live stream of super chats, which is not a bad problem to have.
It's like, this is
I guess I will talk
self-reinforcing.
about it for a minute.
Oh,
The
okay.
difference between first and second degree, and you're asking that I submit second degree, and it's in the instruction itself on the bottom of. I don't want to say bottom because I don't have them displayed as they would on the page, but on instruction, the instruction you've requested, which is 1022. Under the heading difference between first and second degree reckless homicide, it says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Then, of course, the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser. Where's the absence of evidence of utter disregard for human life?
There was a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose. If the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, let's hear from the defense.
Element 3 is the circumstances of the conduct showed the utter disregard for human life. In terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first-degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And don't let me forget, please.
I've discussed it with him.
Yeah, but I had to talk to a
Right.
person. The instructions says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life, consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He was firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Good ruling, Judge.
Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him, and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain. And we're talking about reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that could have fatal consequences?
I would, but the defendant denied that it would.
No, he did not.
No, that's a mischaracterization.
I didn't hear him deny it. He said he was protecting his own life.
Is the judge going to dismiss
he
this
was-
charge?
When
That'd be
he
great.
was
He is.
asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicated, and he
objection.
responded, I was trying to defend my life.
He was also asked the line of questioning,
If so, Twitter's
you knew
going to
you
go
shot
wild.
4 shots
Yeah.
that you would kill him, and he denied that he would have that knowledge. So I mean, I agree.
No, you
that-
asked if he intended to kill him.
I mean, I obviously think that it's utter disregard because that's what we charged it as. And that's what we have presented to the jury. But I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the standard, not what we think, but what a juror could do.
I wish I knew the exact answers that were given.
Get to the
I'm
record.
not sure, and I when I say that, it doesn't mean I'm embracing your interpretation of what that would mean, but it.
I want to think
I
you're
would
right on
want
the
to be
facts.
sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
And you ask the same questions over and over.
Nice. Come on.
That's
Do
also
it.
one of the
Do
reasons
it.
why you should have a shorter cross, because it can get lost in the weeds easily.
Well, and if you're ever reading through a transcript for an appeal and it gets repetitive, it can be really hard to find that one question that you need.
Yeah.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
Nice.
Whoa.
Wow.
That's saying he's denying the
Yes,
motion.
Yeah, he's going to deny it.
homicide. I'm sorry.
So you're saying if the jury finds the lesser
On this charge,
and the defendant objected
over the defendant's objection,
and you accepted it,
right?
you felt it'd be reversed?
Yes. Unless you can come up with this crystal clear language that
You're
the
understanding
defendant-
now, fat boy. That's what he said.
Oh, there.
And
The
again, we're
prosecution's
back to-
already going to get mad.
The dejection on his face.
You can
is
see-
palpable.
circumstances
Yes,
of
You can
he's
see him
seething
getting
right
angry.
now.
conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor. But when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's dispute about that. But either it was it would certainly be reckless under any circumstances and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference because when he's asked about his intent, what was the question you're saying again?
Is he talking himself out of it?
No. He's
There was a line of questioning on if he cared about killing someone or cared in that regard. And there's a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
He would have said he doesn't know it'll
Everything
kill
that
them,
he said. I mean, the reality is, everything was an
but he knew it was deadly force.
intentional act. Now they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots,
Good.
we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches by the soot on his hand. So I think that's what the evidence showed. And I think that's really the only evidence regarding the utter disregard portion of the statute. So
If the defense is willing to stipulate to the third element, then that's fine. We can go for it that way. But it seems they're not arguing it. If we want to go that way, then we can.
conversations with lawyers are always interesting.
That's
Especially
why
when one of
this
them's a salty
Um,
bitch named Kraus.
Yeah, interesting is a nice way to put it.
Disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination.
Well, you should. If
obviously it was lengthy
your
and
whole application is based on
I
this
was not
statement, you should have highlighted
The
it.
examination, as I recollect it, was that the defendant
Fingers
was
on his phone.
repeatedly asked
He is. Oh,
Oh my.
Oh,
about
how is that
Judge.
allowed?
Rip
the
into him.
question about his thoughts
Maybe
on the
he's
subject of
googling
the
Westlaw
Are
as
we
we
bothering
speak.
you?
death or survival
Mr.
of,
Binger? Are we
of
distracting you,
the,
Mr. Binger?
target, and invariably responded that he was trying to defend himself.
To be fair, he's trying to line up
He'd
a
be
job
killed if he
interview.
didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to
That's not reckless
utter
disregard.
disregard.
Right. Right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And I'll repeat my statement. If I were to give this instruction over the objection of the defense and the jury found a verdict on it,
It's his way of saying you
I
better
would
object
expect it
because
to
you
be
never do.
reversed.
They already did.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give that
Nice,
instruction.
cute, nice, good for you.
Or submit that verdict. 1345 and
They lost that one.
1347.
Yep.
Okay, this is one indication though of
Second-degree
why
reckless endangerment.
putting the defendant on the stand was so dangerous. Because if they get that lesser included charge, it allows the jury to compromise the severity of the initial charge and go, I think he's wrong, but
Yeah,
not
it is.
this
So,
wrong. And
Any
that's what the
additional
prosecution
argument on
wants.
that?
That's why it was so dangerous to have him on the stand.
And just
So
a
to-
subtly different answer here would have been enough.
Right. So to clarify, what the prosecution was doing here was they were trying to introduce a lesser
Your
included
point to
charge,
me
right?
that
They weren't.
He
So it wasn't that the
couldn't
defense
know
was trying to get rid of the
Mr. McGinnis
reckless
was there, so he's
disregard charge.
firing a
Right.
weapon
Okay.
he admits does not know the capabilities of. He admits he doesn't know how the bullets can react, that he did not know if the metal jacket could pass through his target. And he's really showing utter disregard for anyone in the line of fire as he fires 4 shots, including Mr. McGinnis. There's also bystanders. There's a house directly behind Mr. McGinnis.
This is
So
a
I
nonsense
believe in
charge.
firing 4 shots and
Did they get the house in on
somewhat,
evidence?
I would say,
There's
wild
Lambeau
manner.
Field. There's
Um,
Lambeau
he is
Field,
showing
40
that there
40
could be
miles
argument
behind it
that he-
also.
So get up on the
He
stand
says
there,
he says
Kraus.
it in- I believe again that it's utter disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis's life, and that the second degree endangerment would be more appropriate.
Defense?
Object.
Just give me 1 second here, Judge.
At least he's thinking.
Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions to me are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction.
The instruction on this one is stupid.
It's that he could have utter disregard for.
Turn those wheels, Judge. He's right. It's transferring intent to a target behind the intended target.
Could have utter disregard for the life of Mr. Rosenbaum, but still be sufficiently aware to realize the risk to Mr. McGinnis. And then he, under the law, as I read it, he would have the obligation to exercise his conduct as in such a way as to minimize the risk to Mr. McGinnis, whether privileged or not. He would, even let's talk about his.
Is there any evidence he didn't?
purposeful, even though it's not charged.
Yeah, it
If
should
he
be a directed
intended to
verdict
kill
on it because there's no evidence that he did.
Mr. Rosenbaum, and whether he was justified in that or not, he's still required to execute his intentions
If
in
this,
a way
had,
with the minimal,
if this charge had been there from the outset,
or to minimize.
it
the
should be
risk of
removed on
Mr.
directed
McGinnis.
verdict.
So and that's a.
So why would you
jury
allow it in
determination.
now? Because there's no
I'm not
evidence to it.
suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it in such a way that I don't hit anybody else.
In
That's
0
really
seconds.
what the
Yeah,
jury
exactly.
Yeah.
That's always been my thing. With what
asked
time?
to determine. And there are instances.
Just fire up your
that you
time
could
machine
imagine
and
where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances.
Yeah, not this
But,
one. There's no evidence. We had a whole trial. There was no evidence. that he was
although
being
for an
reckless.
intentional, then he'd be guilty because he intended to kill someone else.
Yeah, that's
the
the
argument is
yes.
Intent follows the bullet. You're right.
the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot. There's 5 wounds with 4 shots, so he didn't miss. So the reason that I'm kind of hung up on
He's so close.
the
also,
utter
you couldn't
disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he
and
was
that-
using steel-jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's
Was
what we
it
lawyers get paid to do.
Steel jacketed?
But,
Was that testified to?
Full metal jacket,
and of
close
course, if we were in the jury room and we'd laugh at each other for the things that are being said.
Yes, so
but-
dismiss
but,
the charge.
uh,
I mean, come
That's
on.
why
you know,
dismiss it.
in
That's
the
why no
eyes of
reasonable
the
jury could say
jury,
it.
They could theoretically,
No, they couldn't. Not reasonably.
like how
Not
many angels
reasonably.
fit on the head of
It's
a
got to be
pin.
what a reasonable jury
They could
could
theoretically
find.
think. Well, it does make a difference because he wasn't using expanding ammunition. He was
We
Beyond
don't have
reasonable doubt.
expert testimony on this.
Yeah,
They
And he
also
should have
had-
foreseen that it
Kyle
might
said
have
that
gone
he
through
didn't
and that it
choose
would
the
have made
ammunition
it.
either.
That'd be
Well, that could
reckless,
be
I
on
guess.
him.
But also denied knowing he was there, so the jury could very
He
easily.
did. He did indeed.
Do we have
that was
any
my next
expert
point.
testimony to say that the ammunition would have mattered?
Well, my only argument, Judge, was that if he's using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or
That makes
whatever
some
it is,
sense.
right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's
It's
alleged
not that he
anything
didn't
like
miss.
that.
It's
You
that
could
he's
say that in your argument,
close to
couldn't you?
miss. So there's no
If
way
I
he
left
can
this
hit
on
someone
their
else.
verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the 3rd or 4th shot. There's a graze wound that then traveled who knows where,
Essentially
possibly
missed.
Mr. McGinnis.
That's not a miss. That's
So
a
this
hit.
is not as though
Not a
Missed by
miss.
hitting.
all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had a contact with him. And the defendant says he didn't think he was there.
0.239
So
second
a
shot.
reasonable jury could find that how do you show
was
utter
reckless.
disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right.
Huh. Okay.
That's confusing.
Whoa.
All right.
Maybe-
That jury
Amanda.
instruction is terrible. I mean, just in
So-
general,
so
it's
count
terrible.
3, it's essentially the same issue, except obviously this time the defendant knew he was there. I'll essentially make my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury.
What charge is this now?
We believe that first
Jump
degree is
kick
the most
man.
appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
This is jump kick man. It's a lesser
talking now
included
about
of
the
reckless
jumpsuit?
indifference.
Jump.
Basically, because he missed is the
Yeah.
argument here.
What do you call him?
Blue hoodie man.
What do you mean?
What?
Oh, times 2.
Did you want to respond?
it's the first time I've ever heard that missing someone when you're firing from point blank range means that you're not showing an utter disregard for human life. So he fires Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I don't buy that as logical, and I would ask that you just give 1345.
So this is weird because you have to argue against
if his
yourself on the
conduct-
lesser included charge
the
for the
standard
higher charge.
For the
Yeah.
lesser
Really,
included,
exactly.
I think is
Yeah, just in case people think he switched
there is
teams.
ground in the
He
It's
hasn't.
very,
evidence for
it's very
acquittal on
confusing to the
greater
audience, I'm sure.
conviction on the
Yeah,
lesser.
I think there's a lot of confusion in the chat about
We
Same
need to
stuff.
walk them through what's happening.
What's the difference
We need to pause
between what you're charging
on
and the
in the
lesser?
court.
I've stated what I believe the
Your
difference
Honor,
is.
can
My
you pause so
worry
we can
is that
explain?
the defense, who is, I've asked now a couple times if they're just going to agree that there's utter disregard, and they've not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
We'll
But
explain
they
when we
will
get a
argue
break
that there's
here.
not utter disregard. That they will argue
Why-
the opposite of what they're saying now.
No,
after
I'm not hearing that.
Well, then why not agree to it? If they are agreeing that
Because
there's
Maybe
it's
utter-
your
not. That's
Burden.
why. How would that be?
Basically, he's complaining
They'd
that
be nuts.
they're not going to plead guilty.
Why in the
and
world would they concede an element like that?
Exactly.
well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser
Conceding
included
it
should
right
be
now.
given. They're saying they're not conceding all your evidence. They're saying it's hard to believe that this would constitute or not constitute
This
or
prosecutor is
disregard for
whiny.
human life. Let
This
me
is when the
repeat
dumbest
question
person in
I
the
just
room
asked
thinks
you.
everyone else is stupider than him.
This is not. I don't think there's a dispute in the evidence as to this individual, Mr. Jumpkick.
This guy and Grosskreutz need to play chess.
The
With what
video
arm?
is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well,
There's-
again, I'll stand by the prior arguments of the defendant's own statements. And also, I think it does make a difference that he shot 4 times at Mr. Rosenbaum after he was already crumpling to the ground.
Nope.
Um,
That's a lie.
That the fatal shot was as he was falling to the ground. And he stopped shooting at the man in the blue hoodie.
To be fair, he was getting hit by a skateboard when
I
he
think
stopped
the first
shooting.
degree is the appropriate charge, but I think a reasonable jury can say, why did he stop firing? Why didn't he, fire at him as he went
This
away?
prosecutor's
I
never
feared
had
he
a
would come
Russian
back and run at
roulette in
him.
his life.
So I believe a reasonable jury could find that. And
What are you doing?
frankly, if the defense in their closing argument tries to quibble with the utter disregard, I don't know if it's precedent for it, but I think we're going to ask for lesser includeds after that, because we're going to ask for lesser includeds after that. If they're admitting here that there's no way a reasonable jury could find otherwise, if they're agreeing to that, that's one thing. But
Well, if they're agreeing to that, then why are you asking for a lesser included?
Ah, ha, ha.
I understand. I actually do understand what you're saying, I think. But let's do it again. Let's talk about the incident involving Jump Kick Man. What he was doing, what the defendant was doing, firing a gun at a human being.
yes,
He hasn't alleged that he wasn't firing at him. He wasn't saying I was just trying to scare him off with a couple of shots across his bow. He didn't say that. Why he was engaged in it, and he's given his reasons.
Getting
And
kicked in the face.
I don't think the state disputes them. He was doing it to prevent the man from attacking him, and the state says the man had the right to attack him, and the defense said he didn't.
Which is insane.
Either way, he was doing it for what he was doing. It was purposeful.
If it's purposeful, it can't
How
be
dangerous
reckless.
was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not.
That's
know
not the same
that
as
he
danger.
denied knowing or that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns.
More lethal than other lethal.
I don't know if a bear is going to
Yeah.
kill me, but the
I
bear is
think
still
the evidence
dangerous.
most
I don't think that is exactly
Thank you.
He just
exactly
keeps
what-
mischaracterizing Kyle's testimony.
was stated. For example,
got
the
nothing
discussion
else.
about what kind of guns are more powerful. That wasn't
It shows you
actually,
how
I was-
what a great job
kind of
Kyle
intrigued
did
about
that
it
they have to
because it was
lie
a
about
close
what he said to
contact.
try and get
True
him
The
that.
in.
suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. But I thought that discussion was focused on that type of issue rather than your claim that the defendant was suggesting his weapon wasn't dangerous? That it wasn't obvious, the danger wasn't obvious?
He's recommending salads.
I think the only gun Krause has ever fired is the Taco Bell sour cream gun.
Nice.
In his testimony, the defendant said essentially, I was in fear for my life, but I didn't mean to kill him.
Yes.
Is that what he said, or did he, when he was asked, did he mean to kill him? He said, I was just trying to defend my life, or words to that effect.
He said, I did not want to kill them.
Did he?
Okay.
I don't remember. Mr. Binger
He said,
says
I didn't
yes.
want to
Mr.
kill-
Krause
Yeah, but
says
He
that
yes.
doesn't
also
mean he didn't want to
acknowledged-
put the bullets
I
into
think
the
that's
guy.
fair. At some point or another, he did say he
But
didn't want to
he
kill
also
anybody.
acknowledged
That's
that
true.
firing the gun was deadly
But that's
force.
not the element. If for that,
Every single
if for a
time.
first degree, then that'd be another matter. This is reckless. This is reckless endangerment.
Right.
We're talking about the defendant's mind and if he had utter disregard.
No, we're talking about how obvious was the danger.
We agree. The state, under their evidence, is showing utter disregard. What we're fighting about is that it's not.
They do?
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser included. There is a basis.
The
If they,
defendant
if
said,
they accept the defendant's
I didn't want to
testimony,
kill anyone.
that I didn't want to kill anyone, that he bought the gun because it was
That
cool.
would be that. I might even buy into that. I might. Except that that would be if we were talking about a charge of count. Four. Because intending to kill is not an element of this crime.
But it shows whether or not he had utter disregard. If he's
No, it does
firing and
not.
not
Well,
considering.
you're getting to the ultimate fact. And I'm telling you what the factors are and determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well,
Yep.
like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't.
Ooh.
Correct.
So I will not give that instruction
So they lost
or submit that verdict.
on. Did they won on one, lost on two.
The judge is
And
undivided,
reason is
undecided
because
on
I
the
do
I
second.
think number 2, he
Or-
didn't decide.
in the
Okay.
evidence for
I thought
acquittal on the greater.
I think they lost 2, and there's one
And
that's still
conviction
up
on
for
the lesser.
decision.
Yeah, that's right.
None of this serves to acquit. Just to be clear to the audience, none of what they're deciding here is a motion brought by the defense to acquit Kyle. This is a matter that the state is trying to just tack on more and more charges that are smaller than the charges they already
Count
levied,
4, number 2.
and the judge is deciding whether or not to
You're asking
allow
for
the jury to
1017, which is,
consider those charges, or whether he's not going to
You're
burden
asking
them
for
with
3
with
lessers.
deciding on
First,
those
you're asking for
lesser
first degree
charges.
intentional.
And the jury's not in the
You're
room
asking
here
for
for
second
any
degree
of this.
intentional.
So that's why they get to
Or-
discuss so candidly.
First degree reckless or second degree reckless.
Yes.
When we get
So,
a bigger break,
now
we'll
give me the
explain why they're taking the
bases
sides they're saying.
For
It
acquittal
sound like
on
they're
each of
they're in
the
bizarre
greater
opposite
crimes
world.
and conviction of the lesser.
Well, with first degree intentional homicide, obviously there's a self-defense. The jury could find imperfect self-defense and
Okay.
find second degree intentional homicide, that if he did not reasonably believe the force, if it was not reasonable for the amount of force used, the defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second degree reckless showing utter disregard would be appropriate. The defendant said he didn't mean to kill him.
The daily double.
The defendant gave his reasons why he
Which is
thought he
ironic.
had to shoot him. But again, I believe he indicated he denied that he knew it would kill him. And essentially, it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second degree intentional is appropriate because the jury could very easily find in this case that it was not perfect self-defense. As a person who is running at him, being told or perhaps even witnessing himself that the defendant has already shot someone, gravely injured them, has already shot at another person missing, and then gone in to try and disarm him. The jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second.
First and second,
No.
not intentional or okay?
So then the reckless, the defendant testified directly that he did not intend to kill him.
Can you dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about. Mr. Huber, I'm sorry, Judge, if you already.
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea under those circumstances that having an AR-15 pointed up, buttressing up against your chest would not be utter disregard for human life if believed. To me, that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you want to respond?
I'll just stand on arguments before.
Which you've been losing on
This
all day.
afternoon, we may review the
Seriously.
defendant's testimony, and if I find a specific thing that I think changes it, I will obviously contact the parties.
Okay. I embrace the argument of
Strike
Mr.
3.
Shrafsi. And count 5.
So that's rejected. That's number 3 they
you
lost.
and
He just
that
said
Well,
I
they did
raised
get
the argument.
two. They got 2 lesser includeds in there, just not the
showing
third lesser
gross
included.
Kreutz,
Did they?
and that
Yeah.
is
Number
charged
3.
as
There was one that he didn't
intent to
decide
kill?
on yet.
No.
Correct.
In that particular charge, there were 3 lesser included charges.
Is
Okay.
attempted first and then attempted second for very much the same reasons as Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away
Oh,
from the
Bayer does
defendant when
have a
he
lapel
fired.
pin.
And then
Oh, he does. Yeah.
the next
Weird.
Just
It's
lesser
camouflage.
included, if they don't find intent, is the first degree reckless endangerment. So I've requested that, and then obviously I've requested secondary reckless
We'll
endangerment.
explain this in a second when
which
they're done.
We've rehashed a few times now.
Depends.
Judge, I don't have an objection to the lesser included on the second degree attempt. It's the same argument. The court heard the evidence and the distance. Mr. Grosskreutz testified that he was about 3 feet away, whatever it was, from him when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that attempted first degree, well, you can't attempt a reckless act, right?
It's true.
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit the books on that.
Doesn't make logical sense.
That was certainly once
sense.
the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness because I don't think you can attempt a reckless act. So I'll leave it at that and let the court.
Yeah.
I think that's right.
How can you
sounds
try
like
to be? How can you try to be not trying?
But I think somebody would say you're the behavior.
No, if you drop an
is either-
let's say you drop
it's
an
either
envelope off
reckless
a
or it's
bridge,
not.
you're being
I
reckless.
don't know how you can attempt to be reckless.
That
or
itself
attempt to be
is
negligent.
reckless.
I don't know how you
Intentional
can do
act.
those things.
You're intentionally dropping an envelope off a bridge.
We just
Yeah, but
basically agreed
that's
on
what- that-
the kind of on Mr.
That's
Huber
not
that
But you're
attempted.
not intending to hit
homicide is
anybody.
appropriate. Mr.
It's not
Grosskreutz
attempted
did not die,
recklessness.
so the
Just a
appropriate
second.
charge in this point would be the first degree recklessly endangering safety. The jury could easily find that the defendant intentionally shot Mr. Grosskreutz, which is not, I guess, in dispute, but that he did not mean to kill him. The defendant said multiple times, "I did not want to kill anyone." The jury could also find that shooting someone in the arm, if they find that was where the defendant was aiming, would not be intent to kill, but it would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included
Yes.
statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll have it. We'll do it later. I don't know. I'm going to think about this one. I'm inclined to agree with Mr. Kraus. Okay.
On count 6, we are not requesting any recklessly endangering safety charges, so we can skip that argument.
Bless your soul.
What?
Now, the defense has submitted, and I don't think you submitted anything standard, except standard on that.
Our position is they've never raised the affirmative defense. So that's why we didn't do it.
At the trial.
Correct.
Let's see.
And
It's not an affirmative
obviously, they
defense.
can argue otherwise, but that's why we did not prepare one. Obviously, they can argue otherwise, but that's why we did not prepare one.
Wait, so now we're talking about the minor possession of a firearm charge or of a deadly weapon charge. Again, they're alleging that the exception is an affirmative defense, which it is not, in my opinion.
I don't recall any evidence, correct me if I'm wrong, as to the third element of the second defensive matter, which you cite on the second page, on the third page. Item number 3 on the third page. I don't recall that evidence.
I would agree there was no evidence that he.
Then how can I give that instruction? Oh, because they have the burden of proof.
Yep.
It's not a strict liability offense.
Yeah,
He's 17 years old.
okay. Yeah, if there's an absence in the evidence, that's kind of a problem for you, no?
What do you mean?
You would need to disprove the affirmative defense.
We don't believe it was ever raised. They never gave any evidence as to barrel lengths.
They
or
don't
that
need
it-
to.
it
Oh, yes,
raised
there
the
was.
barrel length.
There was definitely barrel length evidence.
Did you see
Let's look at
Sheriff
the
Easton's
four
big
inches.
grin?
Cross-examination
He
of the state's
was,
witness.
Whenever it happened, it was there.
And
Well,
there
now I'm not sure. There was evidence of the length. He had the ruler out and he had measured the length of the portal. That,
I asked Detective Andrew.
did you?
Yep.
Assuming that to be true, then that would then that was less than. Excuse me. It was the barrel length was greater than 16 inches.
Sorry.
Wait a minute.
16
Either the
inches
barrel
or
length
greater.
was less than 16th or the overall length was less than 26. That was in the evidence?
What I asked him was there any, did he believe, I want to make sure I have it right so I don't misstate it. Did he believe that the barrel length was in violation of the law?
What law? I mean, there may be, I don't know what laws there.
There's only one law on barrel length.
Yeah, but not with respect to minors and that other stuff. You didn't realize
That's the
about that.
law. You can't
Okay,
have a
you're
gun
talking
that's,
about, okay, okay,
and that's built into
okay.
this
Well,
instruction.
he certainly, come on, it's not a strange issue in this case. I mean, we've been talking about it for months.
Well, and I agree with talking about it for months, and the defense should have measured the barrel in front of the jury and said the
You
barrel.
have the
length.
burden of proof.
You
That's
didn't
great.
prove it's a
You
short
should
barrel.
have
They
measured
raised
the
it. They
barrel.
never raised this issue.
Well, did he ask the detective whether it was a, what was your question as you recall it? And this is going to be dependent upon what the actual evidence was, but what do you claim it was?
When he took the gun from the Antioch Police Department, did he believe that there was a violation of the law as it related to the barrel length?
That goes to his belief in what, and they never specified which law.
They have to raise the issue.
I understand, and I don't believe that they have. And there's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain
I have-
authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming
Okay,
it's
I
in the
gotta go,
alternative.
guys.
And the state is
See you
always
later.
saying that it is not.
I'm gonna try
Bye.
pop in also. Let Eric know I'm gonna try. to
Well,
pop in.
if the court finds
Okay.
they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Trossi just said it was belief. We'd have to get the exact question, but I don't believe,
The exact question may become important.
so I don't believe that is raising it. And the defense had every opportunity. They brought the gun over here most every day the last few days. They could have gone over any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof of it's on the state.
I understand that, but it wasn't raised. Is our point.
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant or what are you claiming you said?
I asked him if there was, I know I asked him about it. The question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.
Because this is their screw up. This is the state screw up.
Or is not
Or-
in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with.
You have to show one of the three. You have to show one of the three.
You haven't
No,
shown any
no,
of them.
no. What am I saying?
It's all of them.
We have to show.
The or
You
makes
have to
all-
show any of the three which
He
the
failed on all
defense
three.
has put in issue.
So
The defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And Judge, we can unpack this for a minute. So the
This is a
exception
critical
says
moment on this charge.
if you're, it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay, that's one way you can be convicted. And it says, or are in violation of Wisconsin statute. I think it's 29. 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay, so I've conceded because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint.
Understood.
And the complaint was adequately pled under the law. That was
Now we
not
finish
endorsement
trial.
of the state's position on the case. And to use a trite expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires.
If they're not writing, if they haven't already written that motion to
Do
dismiss
you
on
dispute
all
the
these
fact that
charges,
You need to prove
and they're not writing
that the
it,
defendant was under 18
If they haven't already written it, they're
at the
nuts.
time of the incident.
Yeah.
You don't. That's
They
not
should
an
have walked
issue.
in the door with
He's
that.
under 18, yes.
And that the barrel length was less than that allowed by law, or was not within the range permitted by law.
We don't have to prove that.
You don't have to prove that.
yeah, look at Sheriff Easy. Yes, they do. Yes, they do.
I mean, there's no real. Our argument is that they did not raise it. I don't think it's really a disputed fact, but we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5.
Go ahead. I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So
Well,
if the
It
statute
makes no sense. You're out of luck.
well, if the statute is valid, it's clear as day that
Void
it
for
says
vagueness.
Yes.
a person under 18
Clear
years
as
of age.
day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law.
If the exception
2A is quite
is
clear.
confusing, then the whole statute is confusing.
Sure. Any person under 18 years of age who possesses or goes
Well,
armed
that's
with
not
a
the whole
A
statute.
moron.
That's not the whole statute.
Yeah. There's a separate exception on 2A that he's
he is
arguing,
not in compliance
ignoring
with
3C.
29.304 and 29.593. And I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
gonna
Under
be scoffed
16
at again.
cannot, and that is what 29.304 is addressing. The statute is addressing hunting.
Only in
No,
part.
the basic law is that the rubric is not part of the statute.
Mm-hmm.
The title.
Yeah, the title's not part of statute. That's right.
Yep. You're gonna get.
The title is possession of a dangerous weapon by a person under 18.
That's
not
not
part
part
of
of
the
statute. Oh, thank you, Judge.
No, I learned it at an earlier time when we called it the rubric.
Mm.
Tell it to the shell.
The statute says that. That's what it says in 2A.
Let's go,
He learned
Judge.
Um,
Dismiss this charge. I'm rolling on it. Come on,
His
Judge.
position is that he is not in compliance with those two. and that they have not raised the
Look at
short barrel
Chirafisi.
shotgun issue.
For what?
The short barrel shotgun issue, but they don't
He
really
knows
have
he's
to
winning.
because they can try to raise the other part, but they have not done that either.
By his age, it's raised. On the second part, it's raised.
Yeah, that's true.
So that's it. And
Boom.
So that's,
I just want to make sure I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute.
yes,
Of
excellent.
29,304. I am not focusing, and I'm asking that it doesn't apply, the hunting part. If you read the Legislative Bureau, what it says is if you're 16 or 17, there is an exception for you to possess a firearm,
It does say that.
semicolon, done. It has nothing to do with hunting. Nothing.
Not a thing.
This is going to ruin so many people on Twitter
I,
who've been arguing that this
my
is
inclination
illegal
now,
possession.
once again, I'll tell you what I'm inclined to do, is to
Dismiss.
inform the jury.
Oh no.
What?
No.
Put
That
it-
is-
Where's
see.
the jury question?
Well, this is still, I think they're on jury instructions. So this isn't in their motion. They're not arguing their motion to dismiss right now.
Yeah, still. It's a perfect time to dismiss it anyway.
Yeah, Judge.
Sua sponte, move to
Yes.
dismiss. Sua sponte, move to dismiss.
Legislative history only becomes an issue when there's ambiguity. There's no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons.
That face
So,
that he made right there?
Exception to the
You interpret
dangerous
the
weapon
statute in a way
definition
that
is in
makes
3C.
sense. And the way that it makes sense is that
The face
simply
the judge
because
made there?
he's
Super
17
memeable.
does not automatically
I'll be disappointed
negate
if I don't
2A.
see that.
Well, I raised it earlier in the case, and it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I don't think so. The penal laws are construed strictly.
Mm-hmm.
Vague
Mhm.
laws are. Who is that emperor from
Here we
way
go.
back in history?
Claudius.
Who posted the laws?
Roll on your
Childhood.
emperors. I got
Pillars so
Augustus.
high that the people couldn't read them.
Claudius.
He's talking about his
That's
childhood
been used
friends here.
by lawyers and judges for centuries
Uh-huh.
about the requirement that people be given knowledge of what the law provides.
This is
Thank you.
Prometheus.
And the
said.
basic law, and it's chipped away a lot of times
Lu-
with the appellate court decisions
Rule
that
of
are made on
lenity.
the subject of and try in efforts to preserve the statutes because some of them
Oh,
are
stupid.
quite messy.
Hmm,
and-
stupid.
That's
Messy
not a
slight.
criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what
So-
is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to
Yes.
acquaint
Void the
herself
charge.
with what this
Yeah,
says?
yeah.
Make them
Do it.
appeal it.
Sua
Make the
sponte,
state
move
appeal.
to dismiss.
the defendant, Mr. Black's stepfather, the defendant's mother all knew he could not legally possess this gun.
No, that's not what they said. They said
That's
he
why
could not
it's
buy it.
up here. That's why Mr. Black bought it. This
Is
2A
that the
is very
standard for
clear.
interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
Clear to normal everyday people, and it was clear to these normal everyday people.
That's not the
No,
statute
it was
about
very
buying a
clear that-
gun.
Under 18 cannot possess a dangerous weapon.
Someone says.
They don't know the law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
Obviously, we're responding to your.
Well, but the point is, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't
Keep off the grass, Judge. Just keep off the grass.
don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse. So people are charged to know that, unless it's written on the top of a pillar so high people can't see. People, if they're given legal notice, that's why they publish them in the newspaper. If people are given a legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right.
What was
Yeah,
Dominic
that's
Black's?
I can tell you, I've put
That's an
many hours
intent
into it,
question.
so have
That's
you.
the only time that matters.
And
Non-strict stuff.
how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
2A is very clear.
So clear that
the
the judge spent hours trying to figure it out.
I'm going to, my intention is to instruct on what he submitted, without page numbers, I might add. Looks like the third page. It starts statutory definition of crime. And down to funny. Where it says or. So it'll be exception, the state must prove, etc. Then number 1, the defendant was under 18. Number 2, and that the dangerous weapon was either a rifle, etc.
No, it's already in
You
evidence.
can search the evidence to find out if you can prove beyond a reasonable doubt that that's true, so that it can go to the jury.
Oh, so he's saying he might remove it.
All right, now, is that it?
Move for directed verdict.
The
The state got
805,
does all
810,
their motions
815.
first, I guess.
as well as
Any
9.
dispute as to those?
805, no.
Okay,
810
we
and
just lose?
815 are the retreat and provocation instructions, so yes.
okay, go ahead.
Well, I guess I would ask this first, Judge. As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals. So that is why Mr. Rosenbaum then gave chase to him. The defendant,
Based on what evidence?
Stupid.
the defendant then had a duty to retreat. He retreated. Instead of giving notice of his withdrawal from the fight, he turned and pointed his gun again at Mr. Rosenbaum, an unarmed civilian, which he admitted he knew he was unarmed. And that continued. So no, the provocation is not his mere presence. It's not his mere presence with a gun.
Yeah.
We will argue that the video evidence, contrary to the defendant's testimony, shows that he raised his weapon at individuals, and that is what provoked the attack by Mr. Rosenbaum.
So, Judge, yesterday, obviously you know why we were fighting about what that enlarged photo. And I don't think that's I think that evidence is open to interpretation, certainly. I would argue to the court that while Mr. Krause can say that's what they believe it shows, I would submit to you that what the testimony is Mr. Rittenhouse is shortly before that yelling friendly, friendly, friendly. I think if you look at that picture that you saw yesterday, it's open to interpretation. We know he's wearing a strap from the harness over his shoulder. The other thing that if you look at the picture closely, he's standing like he would be firing or pointing that gun like he's left-handed.
Pasobiec.
Look at the picture. His left foot is back, his right foot is forward, and he's open like you're looking at me now. So in every other instance where you observed a gun being fired, he's firing it from the right side.
It's contrary to how his harness is set up.
His gun hangs this way. Now they're saying that photo shows that he was standing and picking the gun up and doing it left-handed. I think that photo is open to interpretation as to what it is. We believe that it shows a side mirror of the Duramax and part of his strap from his firearm or from his sling. That's open to interpretation. I completely understand that. However, you
Well,
also
it
heard
shows
testimony
basically nothing at all.
from this person from the state crime lab, who said he couldn't really answer, and I don't know what you thought of his testimony yesterday, but he really couldn't answer a lot of questions on, and that's why color was so important yesterday, on how the pixels work, and he couldn't say what color those pixels add, and I think that's relevant. Now, it is our position, and I think the testimony supports the idea that Mr. Rosenbaum provoked the attack.
And Mr.
Rosenbaum provoked the attack. Mr. Rosenbaum, there's testimony from two people that Mr. Rosenbaum threatened to kill Mr. Rittenhouse if he caught him alone. You heard the testimony that Mr. Rosenbaum yelled, "Gun, gun, gun," and then you know what was said after that. He's chasing him down. He yells, there's been testimony that Mr. Rosenbaum yells, "F you," before this happens. Mr. Rosenbaum has a gun pointed at him in the parking lot and doesn't stop running toward Mr. Rittenhouse. And if you give 815, which is the provocation instruction, I would submit to you the only way that Mr. Rittenhouse then can be acquitted or found not guilty of the charge is, one, he exhausts every other reasonable means of escape. Two, he withdraws from the fight, and fight is the language in the instruction. And three, he provides, sorry.
Well, go ahead, finish, and then I'm going to tell you why I don't agree with what you're saying.
Okay. Well, I'm looking at 815, but
I'll interrupt you now and tell you.
Okay.
You said if I give that instruction,
Yeah.
then the only way. No, the jury may not believe the predicate facts upon which the instruction is based. So he could be acquitted as long as the jury does not believe that the defendant's behavior was provocative.
That's the first line of the instruction.
Say that again.
That's the first line of the instruction. You should also consider whether the defendant provoked the attack. The defense is still able to give forward their version of events. We have multiple videos in addition to this photograph. And also a defense exhibit number 41, which has its circle on there where the defendant is raising the gun at someone in front of that Duramax. That's an exhibit they have gotten into evidence. So there really wasn't much dispute of this until a few days ago. And that's fine. They can dispute this fact. We believe it's very clear on video that the picture itself is just one little portion, but on that drone video, both the full version and the somewhat zoomed in version that has been provided, it's very clear. I saw it on my television at home immediately upon watching it. So that's our argument, is that he provoked it by doing that. Now, as the court has pointed out, this is not forcing the jury that there's it's not forcing their hand. They don't have to find provocation. You should also consider whether the defendant provoked the attack. And that is a consideration, and that is a point of contention in this case. And I believe it's an appropriate instruction for both incidents.
Judge, the last
I
thing-
interrupted you.
No, that's okay. The last thing that I was going to say is it would also require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight or the attack. I think under those circumstances, that's impossible to do. But more importantly, I have found a case, it's from Kenosha, on provocation and what that means in terms of a self-defense. That is State versus, and I'll just spell it, it's Boughnet.
Bonet.
Boughnet. Ghneit. It's at 97 West 2nd, 687. And in that case, there was a gentleman in a diner, and people walked into the diner and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face.
Oof.
And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language he used, and then ask the guy to come outside?
Big
And
twist
the
is going
court
to be
said
no.
he did.
Oh, okay, right.
So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this record to support the idea that Mr. Rittenhouse provoked this attack. I don't think that that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
Mayor, I agree the photograph alone would not give the basis for provocation.
But
the photograph is the last piece of evidence that was submitted on this. Detective Venturini testified to it. We have pointed it out on videos. We pointed it out to the defendant on the video.
The detective who wasn't there.
Gave what I believe to be a lame explanation for it. So, and again, the defense's own exhibit has it circled on there as it happening. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I've not given my full argument on provocation yet. The FBI video, well, let me go back. The Corey Elijah and the Drew Hernandez, actually Frank Hernandez videos, shows the defendant walking behind Rosenbaum, Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the Ultimate gas station, then Mr. Rosenbaum starts running. That provokes the defendant, who is actually very slowly and casually walking for quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then, and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So the defendant runs onto the scene and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground and he raises the gun. And I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski. That is all in evidence. It's in a defense exhibit.
Can I see that? Is that readily available?
This guy is so full of crap. It's aggravating. I don't understand why they thought Gage Grosskreutz was like credible. Because
the state's position is that the running after Mr. Rosenbaum probably in itself is enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense. There's no one around him at the time except an individual in a wheelchair who's
except for the
behind
person
him.
He's
he raises his gun. I would
except a guy
guess
with a
because
gun.
he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches. He somewhat drops the weapon. He keeps two hands on it and then he has a duty to retreat at that point under provocation, and then he runs. I understand why this
And then he runs.
instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation.
They have no idea they're losing this case. This guy really believes.
Oh, wait a minute, no.
I mean, I'm concerned that they might be able to thread the needle
See if you
here.
can find it. Which exhibit are you talking about?
Talking about the compilation video that the defense put into evidence, I believe it's 41.
I have it on my screen right now on my computer, Your Honor.
I
Then
have
you
it on my
said-
screen right now at
Well,
my
then you said,
computer.
we'll see if you can match it up with what she's looking at. Then you said that something about the one person running after another was provocation. Well, how is that provocation? We're talking now about you're alleging that the defendant was running behind Mr. Rosenbaum, and that was provocative?
That he chased him there.
You said didn't know he was there. How's he chasing him?
He's walking, especially in the video that was put in yesterday through Mr. Hernandez.
Yeah.
He's walking within steps. Rosenbaum and Zeminski are lighting the garbage can on fire. He sees my client walking down the street with a fire extinguisher, and there's fires down at Car Source. Mr. Rosenbaum knows where he's going. He's already threatened to kill him. He sees him coming. He's got very distinct purple gloves. He goes down and he lies in wait. There's no chasing going on whatsoever.
Where's the chasing? And where is the chasing? And how is that provocation?
The provocation is the raising of the gun.
Oh, so
So the chasing is irrelevant now.
That the chasing was provocation,
I believe it
which
adds-
of course it could be
I believe it adds
if it's
to
in the
I'm
evidence.
sorry. I believe it adds to the provocation that he chased him there and then immediately raised the gun.
He wants the instruction, and then he's going to argue what he just said 5 minutes ago.
Well, and we're free to argue that.
Just like we're free not to stipulate to the third element.
Oh, Richard, shut up.
Yeah, don't get petulant.
What am I looking at?
Judge, yes, keep asking the question,
circle.
what am I looking at?
Totally
Because
displaying
that's
it.
what the jury is supposed to discern this fact from. There's obviously reasonable doubt.
Show me with the pointer what you're talking about.
I'm just pointing out that the exhibit indicates he's pointing a weapon.
Huh?
I'm just pointing out that this defense exhibit indicates he's pointing a weapon. We have much clearer video showing this.
Show it then.
No, you don't.
Where was that? Why didn't you bring it in trial?
First of all, why did the defense bring that to trial with those annotations that say could be Rittenhouse pointing gun? Those are hearsay and should have been scrubbed.
We'll take a
Yeah.
break.
What's he taking a break for?
Richards is leaving the courtroom, it looks like, to go get something. Or go to maybe go to the bathroom. I don't know.
Law book?
This, guys, when we were talking about the foundational issues of all of this evidence, this is a big part of it. There is no reason on God's earth that the defense or the prosecution should have been able to introduce a video that has annotations put on by somebody else who's not there to testify to those annotations. That is hearsay. It's opinion. It's prejudicial. This video should not have been in evidence. But apparently the defense is the one who introduced it, which makes even less sense.
We have seen utter incompetence from both sides here throughout this trial. Utter incompetence. Sheriff Feasey seems like he's the only one there who's ever tried a case before. The state, Binger's cross-examination was textbook, awful cross. We've seen bizarre introductions of evidence. We've seen the defense counsel sit back mutely, failing to object on basic crazy evidentiary issues. Objections on hearsay, objections on relevance. We saw them put this guy on the stand, their own client on the stand there. They exposed him towards waiving his Fifth Amendment right. And he said, look, we're on the same board. He wants to testify, and we're on the same page. We support that decision. It wasn't over our objection. So they're on the same page. And your responsibility when you put him up on that stand is that you protect him like he is your own child. And you stand up there, and when he's being badgered, you're sitting back there with your arm back, like, oh, yeah, I got nothing to do. I'm thinking about my next vacation in the Caribbean. And we've seen so much malpractice here. I don't understand why they didn't move for a directed verdict before they put their case in chief. There was no downside there. If it gets denied, okay, gets denied. Then they know if any of it gets admitted. After Gage Grosskreutz gets up there and says, I held a gun on him, right there, boom. Directed verdict on that one charge. On that one charge. So we know we don't have to think about that moment anymore.
I
We don't have to deal with that.
I think the downside, the theoretical downside would be if you do the directed verdict and then move into your case in chief, you lose the ability to raise or to argue on appeal. And I guess
we heard that.
But then that doesn't make sense.
Again. They can raise the same motion again today.
Right.
And then appeal. And then if they lose today, then appeal that.
Where I come from, if you don't do a directed verdict at the end of your case in chief, and then if you don't renew it at the end of your own case in chief, you've waived it.
Yeah. I don't. It's just astonishing. And the prosecution, we've seen over and over again. We're like, wow, the best person who's asking questions here for Kyle is Binger or Kraus, where he goes up and blows up on, and he everything blows up on his face when he brings up De Bruin. I mean, they did a better questioning of De Bruin than was done on direct. They made Grambo look good. I'm talking about the state. The state made Grambo look good. The state made Photo Chad De Bruin, the photographer there, look good, and made the state look evil and corrupt, how they're trying to get him to change this thing. Every good moment from this trial has come from either the state screwing up their cross or Kyle actually on the stand and just being like, look, I'm just trying to save him. I'm just trying to not die. That's essentially what he was saying. But every time one side had to get up there and question the other side, they would literally bungle it. It was just the only person who looked competent at all is Sheriff Easy. He's shown real competence at times. I mean, even he failed to object so many times. How many times were we sitting here screaming, object, it's hearsay? They're putting up here documented footage, which was like no foundation. There's hearsay screaming, people talking, screaming, you're a militia, you're going to kill people. It's all hearsay. And when all this hearsay crap comes up there, they just say objection hearsay. What about objection? The fact that it's labeled saying Kyle militiaman, the guy you're going to indict for murder, whatever file name they have, that they have to show that up there. There's been so much tainting of the jury over and over again.
Well, I'm
sorry. I'm ranting.
I got a rant of my own, but I'll save it until after they're. Doesn't look like they're talking. One thing that just annoys the heck out of me with these things is how many lawyers run firearm-related files without a real grasp of them. And if you don't know, hire somebody. I mean, there's ballistics guys out there. There's all sorts of people, and lots of them are not expensive to sit down and just talk with. Might have to continue this here in a moment.
You would have the burden to prove beyond a reasonable doubt the accuracy of what you're saying. You have to just prove the defense, but yeah.
The defense, are we back on?
Go ahead.
The defense's position is that Rosenbaum was yelling gun, gun, gun. Why do you think he was yelling gun, gun, gun? Because Mr. Rittenhouse had a gun. Now, I mean,
go ahead. I'm not trying to interrupt you.
Yeah, the court is exactly right. We would have to prove this. We have testimony, video, and photographic evidence of this occurring. It is our
testimony is someone looking at the video.
I agree, but the jury should be given the instruction that they should consider it, because if he raised this gun, it's clear provocation. So it's up to us to present the proof, which obviously will be a central piece of our closing argument, with the, I think, 3 different videos.
They're introducing
This
proof in
defense
closing?
exhibit, which at least indicates that it's there, and the testimony of Detective Antaramian, who indicated he saw this, I believe, after cross-examination or on cross-examination. And the jury can decide it. We don't have to prove it beyond a reasonable doubt to the court or to the defense right now. We have to prove it to beyond a reasonable doubt to the jury on Monday. There is plenty of evidence in the record to indicate that, to give this instruction. I understand it's problematic for the defense. I understand it's problematic for their entire theory of the case that they presented in their opening. But that doesn't mean that we shouldn't get it, because we have presented evidence of this provocation, that the unlawful conduct provoked Mr. Rosenbaum to attack him. If the jury buys our argument beyond reasonable doubt, fine. If they don't, that's their prerogative. They're the fact finders, not the people in this room. We have presented facts for them to consider. They should be given the opportunity to consider those facts in this light.
In this light.
Judge, I don't think that photograph, maybe I'm wrong, shows anything.
Thank you.
Well, that's for the jury, though.
I understand, but they're asking out of that photograph to give a provocation instruction.
No. We're saying
There's no other evidence.
That's
We're saying
exactly
that-
what they're saying.
No, just a minute.
There's no other evidence. We've talked about the chase thing, right? But every other thing that's come up about what Detective Antaramian said, what anybody else has said, comes from that photograph.
Thank you.
That's it.
No, it comes from the drone video.
Where
And
the freaking drone video?
The defense knows this, which is why they've fought so hard to keep this out. This is not some
The
new
defense
revelation. It's in the
introduced the
police
drone
reports,
footage.
their allegations that he pointed this gun. This is only to demonstrate that a defense exhibit indicates it. We're not using this to prove it. We're using it to show that even the defense exhibit indicates that this is there. We have testimony, we have video evidence, we have, I believe, photographic evidence that helps, but to say that we're basing it on a blurry photograph is completely dishonest.
Accurate.
They've seen this video and they know what's on it, and they know it is problematic for their defense.
I can't rely on what you think they think.
I understand. I'll change my argument. But the simple argument is there's plenty of evidence that the state has provided that he raised his gun. It was a known part of the discovery in this case. We should be able to argue that, and we would argue provocation, so the jury should consider it. And they clearly, as they've pointed out in their evidence and their opening and their argument today, they can rebut that and indicate we have not proven it. And that's up to the jury. That is not up to us. So I believe we should give the instruction is appropriate. It's add the following when supported by the evidence, and it is supported by the evidence.
There's been no secret about my lack of technical awareness in the trial here, and I thought of it. I decided not to intervene yesterday. I did ask Mr. Armstrong some questions to try to better understand what was coming off, but I didn't go further into it in spite of a temptation to do so. When I get messages from some of my friends, my few remaining friends, I have they come as texts, and then they start belittling me or whatever in one way or another, and it can be quite lengthy, the exchange that's going on between them and us, but they're entertaining, and so
What is this
make
about?
It's about
I
how
don't
he
know how to
bungled
save
admitting that
text
picture.
messages.
I think
I haven't figured that out, and I haven't.
Oh,
I have a lot of things that I'm doing, so that's a low priority for me to figure out how to save a text message, and I don't want to leave them on my phone forever. I want it off so that it's clean. So when I look at it, I'm looking just at the fresh stuff. So then I do a screenshot of it and I email it to myself to save it. But I found, to my distress, some of them are pretty long, and they show up in my email.
Okay,
like
I see where he's
like
going.
a little ribbon down the center of the page.
When
Some
I
are even
zoom it in,
smaller
I
than
can't
this.
see shit.
Well, and it's just a blur.
Yes,
Oh my god.
Oh,
We were
my.
talking the other day, one of you two,
it's
about
magnifying glass.
just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. It's making it bigger, but it's nothing but a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence.
What are the other
So
4?
I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos, one unedited, completely untouched drone video, which I think is where you see it clearest.
What?
And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video.
Where?
So we can present that evidence,
Why'd you
and they can
enhance it?
rebut it. I think you're taking the picture wrong on your phone. I'm not tech support.
Pardon
but
me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence.
And they shouldn't
He
be.
actually is,
You watched it on the
for
screen
the
yesterday,
analogy,
whether
he's
you
taking the
formed your
picture
opinion or
exactly
not.
right.
And that was
Well, my
probably
opinion is not what counts, except to the extent that if there's no
Oh
I'm proud to
Uh-oh,
be
God
American.
bless America.
There we go. There's a new meme.
Trump
What's
judge.
that say?
if it totally if it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't
This
make
is really
anything out of.
important.
I agree with you. The ultimate determination
critical.
of what it shows is for the jury.
This is everything.
This
It
is
is
their
not-
only
it has
hope
to
to
be over
thread
the
that needle.
threshold.
it's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if
If
not
the
by
state
the
loses
defense,
a provocation
then in
instruction,
response to
Kyle
their
has to
questioning,
walk on self-defense.
Detective Jeremy testified
They
that
should
he
just go
reviewed
home.
it and saw it, and that was a common question of many people in this case. The photo is like the 5th or 6th most important piece of evidence.
What are
the
the
most
other
important
4?
piece of evidence on this point is the drone video itself, and that is unedited.
Show it.
There are some
Show
edited
us.
copies
Show us
as well
right
that are
now.
helpful.
What the hell are you
But
talking about?
to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaramian. It is in the record. We have evidence of provocation. I can't fathom why, if there is evidence in there of provocation, which we have clearly done, why we cannot argue
Clearly,
it,
it's
why we
blurry.
cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that is
Did you
why we
say
have
it clearly?
trials.
I haven't seen it clearly. Okay.
I have.
Oh,
You have.
Oh.
Why don't you just sit in the jury box?
They're
also?
arguing
Cra-
for something
rein in
saying we've
Kraus.
been on notice from the beginning.
Him snapping at
And
the
if they
judge
wanted
is so
to put
stupid.
on the evidence to prove up provocation, all they had to do was call Mr. Zeminski or Mrs.
Thank you.
Zeminski
Oh.
Yes,
to
there we go.
rebut the
Yes.
story that we have.
Maybe they'll
They
come up
didn't
and
put
close
them
the
on
evidence.
because Detective Antaramian, Detective Howard both know that he's a liar. And they're building their whole prosecution on that without putting him on.
well, they don't have to call a particular witness.
But they don't have the provocation. And, we had all these little things going on yesterday, and I went back to my office, and the whole essence of the problem came down to these 2 facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is again, we're focusing on a picture that I've said repeatedly now is the least.
Get rid of it.
Get
rid of it.
The
Get
least.
rid of it.
Well, show me the best
Convincing.
one.
Well, then if it's
Show me the best
Show
one.
me the good
Show
one,
me
he
the
says.
next one. This man is talking himself into a trap.
Yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about
Bigger's trying to
whether or
help
not
now.
the methods he was using were appropriate, and we showed you. You walked up to the 4K
Yeah.
TV, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
This is not a court trial. You're not the finder of fact. We have facts.
I know it, and that's why I let it go to the jury.
We have.
That's what we're asking.
That's what we're asking, is that the jury be allowed to consider the state's evidence, is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal unless you had made some determination that there was some basis for this.
Tell
What
the
I
judge
made
what
a
he was thinking.
determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No.
Where's the best picture, please?
Please,
Ooh.
please.
We'll show it to the finder of fact.
You're asking me to give an instruction. I want to see the best picture.
Oh, he's getting upset.
It's the.
It's because he
Mr. Stewart.
We'll
caught
show
them
it
in
to the
bullshit.
finder
You
of
need
fact.
it on the big TVs.
You need it on the big TV?
Get the big TV.
Get the big
Just
TV.
or reject the instruction. He doesn't want to show you. Why didn't he want to show you? Reject the instruction.
Get the big TV.
They're trying to gaslight the judge.
Oh, and
Yeah.
he sees it.
I mean, there's enough gas.
That's why he's
going
taking
in
a
that
pause
place.
right now. He's calming himself down.
Nick, if somebody lit a match in there, the whole building would blow up. All the gaslighting going on by the prosecution.
Yeah. I'll go get a TV, Sheriff Feasty saying, look, I got one. There's a Best Buy down the road. I'll be back in 10 minutes.
Believe it or not, I've actually done something similar with AV cords.
Real quick, Russian name says, well, I've taught lectures on computer graphics at university for 4 years, and after thinking about these pictures, I'm even more mad. You can have illusory colors via dithering, and even one pixel can change how human brain perceives shapes. That's CSI Looney Bin.
Are you talking
All
about
right,
82?
bring it up if you would.
What is that?
82 is the slow.
No, I think the best picture is on the original drone or the normal speed one.
73, you say so.
If you say so. Judge,
it's-
turn your ringer off.
Judge,
Turn
I
your
think
ringer.
using the defense, we've
Or-
got the exhibits on our one of our laptops that I think Mr. Stu has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best.
4K because you need the
way to see
visualization.
them. So we can set that up. There is the full drone footage. There is the
4K is
slowed
not
down
automatically
drone
the
footage.
best.
And then, of course, we have the photographs that Mr. Armstrong had yesterday. So,
Native resolution would be the best.
Humpty Dumpty really lost control there.
I mean, unless it's their goal to piss off the judge, thinking that when he gets pissed off, he calms himself down and may then allow something he wouldn't normally do it. Maybe that's their plan. It's risky. I wouldn't do
tell you-
it.
Yeah, but here's the thing, he's appeared, according to
I think they
Westlaw,
just-
Binger's appeared in front of this judge 400 times. He knows how to push buttons and how far he can push and how far he can't. He knew
So
he would never
they're
get
gonna-
sanctioned.
They're going to tell the
again,
judge
I would
that right
recommend,
here
like
he sees
yesterday,
the gun
you
being
watch it on
raised.
4K TV,
This will be hilarious.
If it's not 4K quality.
What's that?
Is it this TV
It's your TV.
adds pixels to something unless it's 4K quality? It does next to
evidence on that?
It's common sense and judgment, Jim.
Oh, shit!
Oh,
Jim,
You're saying I'm lying?
I have no idea.
I'm saying there's no evidence.
calling me a
I'm
liar?
asking.
But
I'm saying there's no
another,
evidence.
Well, it's common
Questionable arguments.
sense.
You brought in this TV.
Yeah,
brought in the
4K
TV.
drone.
You brought in the TV.
They're getting heated because this is critical.
And they know
Takes
their
me to turn
expert
on
just
this.
blew this up yesterday.
Yeah.
I mean, if Richards is 100% right, if you take 844p footage that they have here and enlarge it to 4K, you're doing the exact same thing as pinch to zoom, yet they know even less about the algorithm that's being used because it's whatever proprietary algorithm is being used in the upscaling software that's picked by whatever TV manufacturer they are. And if it's a cord, it's probably like a shit brand from Walmart.
This is the unedited.
Okay.
Is this unedited?
Yeah, this is the unedited.
73.
All right, judge is right there.
The judge, we're going to be focusing your attention right here at the base of this
Right.
sign. Okay, that's where the defendant is going to come into. Go ahead.
I don't think he's going to see anything.
He's not going to see anything. Look,
I
judge,
hope-
don't you
Can't
see?
anything.
Don't you see the gun?
It's crystal clear.
You can stop.
Where's it supposed to be?
How did he perceive a gun being waved?
Same quality as our version.
How did Rosenbaum perceive a gun?
Our
being
version
waved
is
in
much.
that
Our
second?
version is much clearer.
Oh, your version is
Well,
much
yeah.
clearer. This
Yeah.
is the evidence that's admitted.
Mr. Stutz.
So what you're showing me now is, this doesn't show anything. This
Doesn't
is
show
what-
anything.
what the defense-
Yes.
But this is only one of 4 or 5. They have 3 more.
No, they said this is their best one. They
No, I
said
know,
this is the best one.
But there's other ones also. They have like
The-
cave drawings.
The judge
Kyle.
just said, and that's the key. So this is it because that didn't show anything. And of course, it doesn't show anything. It never
Look at
did.
Kyle's expression. Boy, he
Yeah.
knows the stakes are. We're all in
Yeah.
on. He's all in on this one.
The reason provocation is so big is because
Kyle, stop looking at the law and crime camera.
When you
Oh,
sit
it's
next,
playing weird now. Are you fucking kidding me? It's playing weird.
your
Judge, you
case is
saw it yesterday.
garbage.
Totally,
No.
it's a different file.
Straightening the tie.
the reason. So just explain to the audience the reason provocation is such a big thing. This provocation charge is such a big thing is because as Rungle the Bailey was saying, this is how they could thread the needle. Once they can, if they can establish and allow the jury to make a finding that Kyle provoked them, and that mitigates against his right to have a self-defense or changes the yardstick as to what he has to do for his self-defense, all of a sudden everything now changes as what we watched for the last week and a half. And all of a sudden now this flimsy, ridiculous evidence is trying to be used by the DA as a basis to say, oh, he provoked them, and that's the reason why lunatic Rosenbaum went up and charged him. He was trying to protect Zeminski or whatever. And there's ridiculous, clumsy, pixel-added, impossible to see anything. Is there best evidence that he provoked them, and because of that provocation, should be held to a different yardstick and basically be stripped of his right for self-defense.
Look,
And-
it's bugged 4K mechanics, dude. It's bugged 4K mechanics. It's
What
not playing right.
What it really does in terms of the provocation instruction is if you've got somebody who's kind of wanting to convict, but they can't see it, it gets them a way to get past the whole obvious self-defense thing and to say, oh, well, it doesn't matter if it's obviously self-defense because, the gun. So it's not going to help, help the prosecution with a juror who's looking at this sort of fully. But for somebody who's looking at it with an eye to conviction, I think.
Yeah, no, you're 100% right. That this is a critical moment on the self-defense claims, because if they get that provocation in there, it's just like Joe was saying, they have the opportunity in the mind of a juror to mitigate and say, he provoked this, he deserved it, and just having that instruction, they get to read into, he shouldn't have been there, he shouldn't have brought a gun, he shouldn't have walked into the hostile crowd, none of which is actually legally relevant, but in the mind of the juror, it is. And that's why this instruction is so dangerous.
And it goes further. If there's a break here, it goes much further also, because the jury Once they hear that provocation is a basis that we can change our yardstick for measuring Kyle, they won't just look at this moment. In their mind's eye, they're going to say he provoked them by showing up there with the gun. And
That's
that
exactly
now
what I
the
was
judge has
saying
told
earlier
us that
today.
he provoked them, that they can find him guilty because he provoked them. That's if they see that provocation charge, they're not going to be looking at this stupid video. They're not going to care about that. They're going to be thinking about the fact that by he walking around there with the gun, he provoked them, and everything that happened is his own fault.
Yep.
That's the danger of this
That's
provocation
exactly
charge.
what it is.
MSMPCA or CPA, thank you for the sticker of the pair riding a rocket. That was weird. MNSISU says the first to third most important evidence is drone video where Kyle is 10 pixels tall. The fourth is the idiot detective saying he sees that 10 pixels pointed gun. And the fifth is a zoomed in picture of a blurry smudge. What an excellent argument. Do you even know on the picture where Kyle Rittenhouse is right now? Kraus?
It's so clear. When he watched on his 4K TV.
No, this is the regular. They brought their regular.
Right here, this is the defendant. He puts it down. He raises it up right there. He has it pointed until Rosenbaum approaches. Then he runs around.
Try it again, please.
You try it again,
please.
And can you slow it down?
Nope.
We have a slow. That's what you watched yesterday.
This is why you never want to allow slowed down video, is because
here's
it
the
can
gun.
create all these, it should be seen
here's
as
the
it would have
gun
been
right here.
seen.
As
See
no
the
one
guy in the
there
white
saw
shirt?
it. There's no human there saw it.
Yeah.
I can't see
Looks
where
very
he
similar
is.
to that when he points it here, Mr. Rosenbaum.
Well, we know he points it there after he's already being chased by a lunatic.
Here, Stu, let me pause it 1 second and please.
Let me
Let me
please
just keep
convince you.
suggesting this. Yeah.
Pause. Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and then he immediately raises
So gently
up
that it topples over.
like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr. Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area to avoid danger. But if you see right here, the state believes, with all the motions taken, that's the gun. And here's the.
You need a continent-sized TV to see this.
If you're screaming gun, 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 wouldn't that be not to provoke them, but to
We
tell
can
them to go
talk
away?
about this on closings. You want?
I was just curious.
What's that?
I was just curious.
All right.
So why don't you play it from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say. Would you like the zoomed in or slowed down one?
I'd like to see the enhanced one now.
In normal speed or slow speed? Do the zoom in normal speed.
Zoomed in normal speed.
Billy Witch Doctor says, didn't Greer need to get his own HDMI cable when he sued Taylor Swift? Yes, he did. And he went and got a 3-inch HDMI cable from Radio Shack, and it didn't work. The Dragon's Treasure says, I broke my goal of 1,000 in one day, and it's not even noon. Thank you, everyone. Coupon code 4 doors more whores at the Dragon's Treasure for all your anime-themed tea
So
needs.
this is
Gotta
slightly
go.
cropped
Keep it up.
in normal speed.
Is this when you say, Judge? No.
Oh.
All right, now we're at the enhanced video. What they should do is say, Judge, do you realize that that blurry blob that we're seeing the picture of is from
like
this
your
video?
phone.
That's the same thing that we're supposed to be looking at. And so if it doesn't make sense when it's stopped on the one moment where they say it's happening,
So
how are we going to say it's
this is
happening?
the defendant right here. You can see the AR-15 is on his chest. The fire extinguisher you can't see right now. It's blocked by this man in the wheelchair.
For that
But you'll see him walk up again. He will gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it at the individuals who are over here, who I think are right now blocked by this street light. But they're the Zeminskis. Okay, go, Brian. See him lifted right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms, and you see the black gun being raised. One more time, please.
You'd agree if that's true. He's doing it open to the camera.
Well,
So
you know what?
No, I did not say that.
It's okay.
Somebody's pointing out that this TV apparently
So
does
here's
use
the
AI
gun.
upscaling.
Puts it down and raises
Of course
it
it
right
does.
there. He still has it up right there, and then he drops it and runs.
I don't know if you can even buy a TV without AI upscaling right now.
Would you like the slow
Yeah.
down version?
I mean, you
Might be
could, but
shitty upscaling. Might be good upscaling.
Slow down version, please.
I would just remind the judge that's what I would say. Judge, that blurry blob picture you saw is from this video. That's what they're asking you to see in real time. They want to convince you that that's what you're seeing, even though you clearly don't see anything happening.
None of us see
So
anything.
here's the defendant here.
And the
There's
DA knows it.
AR-15
I want to hear him
right
say
there.
it. And the DA knows it.
Play it,
I'm lying
please.
to purpose. The DA knows
So he's
better.
coming in frame, he drops the fire extinguisher, and he raises it right up. He has it up right there. You see him bring it down, and you see him start to run. He's pointing it at Joshua Zeminski, who probably is vandalizing or committing arson, but that's another. We don't believe he has his gun out at that point.
Wait a minute.
Wait a minute.
He fires it. What, I'm sorry?
I said, where's Zeminski's gun? What I meant to say was, does it depict Mr. Zeminski,
Shooting?
Mr. Zeminski's gun?
At this point, no, it does show him shoot in the air.
Oh, that's over later, over there.
Yeah.
I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski
Can you play it again, Brian? He's kind of
or
hidden.
Mr. Zeminski?
You
They're
can't
kind of
even
hidden by this light post.
you can't even point him out. That's how bad the video is.
this is something people never understand with video. Is just how often video evidence is crap.
What I inquired is, well, wait.
What I don't understand is we have 19 different angles. This is the only angle that you could possibly see him waving his gun.
That's what they claim. Well, that and the FBI drone footage from a mile and a half in the air.
Why couldn't they see? Why wouldn't people see it from the other direction?
Because it's made up.
That's what I'm saying. That's what he should be saying.
That he is reported to have fired
Where-
seconds later.
where does
The only
Zeminski
time
go?
anyone sees this is when it's artificially enhanced with pixels being made up. That's the only time anyone sees it.
And they don't even
We
see it
only know
then.
they're there because the FBI video.
Yeah.
You can kind of see they're blurry. We did not try to do any enhancements.
So you can't
on
tell
that.
where he's pointing a gun if he even
We know
raises
from the
it.
FBI video. We know from the FBI video, Your Honor, that they're in this proximity alongside the Duramax. But
Then
because
show us the
they're
FBI
darker
video.
Closed, and the Duramax is a
I don't
dark
think the judge
vehicle,
is gonna buy this.
And of course, other issues with the video. It's not, and there's poles.
But he won't strike the evidence, though.
They're in that
Issues with the
vicinity.
video.
FBI video, which we can show you, does give you.
I've seen it.
It might be helpful after seeing this now to see that because it kind of gives you a very good notion. So.
All right, if you play it, I think I can play it, please, Brian.
I can pretend to know where they are after saying we don't know where they are.
I believe
I
they're
think
blocked by the light post.
they're
They are
blocked.
right here.
I think this is
I
one of
swear
them
they're
here.
there.
moving. It's very hard to tell in this video.
Amazingly,
then
Zeminski's do
they
not
walk down
react
this
to
way,
having
this
a
is where
gun
he-
pulled on them, by the way.
We don't accept the defendant's story that he had his gun out, because in the video, you clearly see Mr. Zeminski pull it out of his pocket, fire in the air, and then put it right back in his pocket. So unless he had the gun out and then put it in his pocket in these few feet, we're not accepting the defendant's story. In fact, we believe this contradicts his story that Mr. Zeminski had his gun already out, because you see on the next enhanced video, you see him pull it out of his pocket and fire it in the air quick and then put it down.
He keeps it down on his side. He's walking right down the sidewalk yelling, "That dude just shot somebody." You can see the gun clearly in his hand.
Well,
Not
I
in this
think
video.
that sounds like a great argument. But did you want to make any?
Object to all of this.
Before I make a decision?
Well, you're going to see. I'm cheating here, right here. You're going to see what you believe that you see. Okay. So that question is, does that video provide enough information to give an instruction on provocation?
And Your Honor, how does, if we take everything they've said, that's true, how does pointing a gun at Zeminski?
No.
Don't steal
Rosenbaum,
victory from the jaws. I mean, defeat from the jaws of
they
victory.
say they don't know each other.
There's no evidence of that. He called Mr. Rosenbaum's dead.
He's screaming gun, gun, gun also because Zeminski just fired. He's screaming there's a gun somewhere.
Any real basis.
Well, the evidence, okay? The evidence in the records of two people is that Mr. Rosenbaum had twice before threatened to kill the accused. So is it, what is the legal effect of a person who, if he made such a threat, what legal justification?
He would
does
have to
have
retreat
to
and
chase
clearly
after
communicate.
the accused?
Oh shit. He would have to communicate to Kyle, "I'm not going to kill you."
In such
if
a way
the-
as to not put the defendant into a position of being a provocateur.
Great.
We are
point.
absolutely
That's not
not,
well phrased.
we are not accepting the evidence that that threat was made, because there are different accounts of where and when it was made. And it's like
Because
the
there's
only
different
5
threats.
seconds not caught on video all night. So, but like you said, Judge, it'll be a great argument. And I do not believe that Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier. If this individual, now remember, there is evidence in the record that he was accused of pointing guns
Threats
at
wear off
other
after an
individuals
hour.
for property
It's amazing.
crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away after admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps stoking a fire that's already been lit, would be provocation.
All the fires
Committing
were
this
by Zeminski
unlawful act would be
and
provocation for
Making
anyone
up facts.
to intervene and try to chase him away, whether or not it's threats have been made. And I know Your Honor takes these threats seriously, but we've also seen thousands of threats to kill that have never been acted upon. This guy,
But this
Mr.
is
Rosenbaum,
by
was
someone
described as
who's
a babbling
charging like a
idiot.
bull.
There's no evidence he ever caused any physical harm to anyone
Was
that
he on a
night.
different trial than everyone else?
And frankly, even if he had threatened, he had no means to carry out his threat. So
What?
Uh,
Look at Kyle's face.
as you said, it's
Are
a
you
great
out of your
argument.
mind?
There's evidence in the record, not just by video, also by testimony. And there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense, but
Shut up.
it should at least be argued as the evidence does support it. And it goes directly in contrast to what the defendant testified to.
think he's not going to give it.
Do you want to respond?
Judge, it's been hashed over.
Well, it's the jury's.
No.
It's the jury's case, and I think they should make the critical decisions.
Oh my God.
No.
Why would you let this argument go? You were winning it.
Why would you?
Why they let the defense is so awful here.
My decision will be to submit the case to the jury with the provocation instruction.
Oh my God.
No.
And argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give the. You didn't dispute the retreat, did you?
I don't think it's. I did. I don't think it's. If you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general legal standard that applies. So I don't think that under these circumstances, there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that. But I don't think it's necessary to be given.
I can't believe they did not continue that argument.
Yeah,
It
is appropriate.
Useless.
In large part because this was that there is no duty to retreat was mentioned in opening. I believe Attorney Trofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be that's been put out to the jury. There should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also,
this is insanity. This is insanity.
Everybody was scattering that, and that dramatically changes the situation.
If you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
Oh my God. How much further can back
the FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin. I don't remember which it was. I think it was Zanin. Video to me depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still they're using clubs and wrenches or whatever else to be doing destruction to those cars that are right in the area which would have been the path of flight for the accused. And I'm wrong about that?
Now.
It's fake evidence, fake narrative. Everything here is.
Video, you hear the 5 gunshots.
Yes.
You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd. And then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that in the southern portion of the lot there is. The defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
watch the video. Let's watch the video.
Oh,
God, defense, you're winning. He hates Krause. He hates him.
They're just sitting there mutely.
Sure, you can put the sound on.
This is the time to dunk on them.
Exactly.
Get in there.
You hit the guy and he staggered. Follow him.
Yeah, don't just give him a chance to rest up, and especially because Krause can't make arguments when he's mad.
So over here, past the hospital.
No one stood in his way. Grossly ineffective defense counsel.
Most frustrating thing is they were winning that argument.
Yeah, the judge
And then they
has
just-
completely on their side.
Can you pause it, please? Or go
Why?
back 2 seconds. The defendant runs here. There's no one in that area.
I will mind
Wait for the
thinking.
gunshots. Which comes in a minute and 10 seconds approximately.
Look at all those people there.
Just let it play. Starting the car.
This kid's being railroaded. And his defense is as culpable as anybody else.
I think this foreshadows what the next motions are going to be like.
Yeah.
There needs to be a motion to well, if he loses, they need to appeal based on the improper admission of that fucking blurry photo and the video enhancements from an expert that's not an expert.
When no one even testified that it fairly and accurately depicted anything.
Highly prejudicial.
They did preserve the objection of that photo from the expert.
Oh, that's
They
great.
didn't from the drone video.
Oh shit. They shooting. Oh my god.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there.
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
Seriously.
ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense
evil.
has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Did you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut. I said he's arguing the instructions. I'll keep my mouth
You
shut.
saw the video, Judge. There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question was the use of force in the situation reasonable? That is contemplated by not giving 8-10. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right, anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court
What?
TV.
Well, I'm not saying
Well-
you want to. I'm saying we should talk about it now before anyone tries.
Well, that's a good point. I don't want to specify one.
They should play us.
Court TV is
Yeah.
They should play us covering
and
it.
I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going. I think. So I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one that where they're commenting on it one way or another.
Uh-oh.
The judge knows
Racism.
about us. He knows about us.
He knows about
The
us.
judge is like trying. He's like, oh yeah.
So unless there's some objection, I don't have any problem with
Anti-Semites.
that.
I don't think it's appropriate.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not going to do it.
Oh,
I
okay.
just-
Well, let's
I
do
just
that.
want to be blindsided.
Let's
so.
do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again,
Of course it is.
I was there. State against Pucci Franklin, Maurice Pucci Franklin. And
Wrote it with.
I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the laws,
Oh,
what the
gee.
cases say. And I think
That hasn't
how
happened at all in this
dare
trial.
us, the founders of the Constitution, have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by telling, always suspecting that the juries are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now?
You should have had a bench trial.
And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Tsarnaev, who's now under death sentence, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, if we're a bench trial and I looked at it 100 times, and I finally decided I better not look at it anymore because I might prejudice myself, I get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, look at that, and then I send them upstairs and they're not looking at it again. And I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
1,000 times.
I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great.
It's going to be a 2-week-long jury.
I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law. And also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance at counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades. It needs to be changed, and perhaps we can do so legislatively. But as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial, yeah. This is crazy. It's just absurd. And
Your
I'm the
decisions
one,
today
I
have been
guess,
kind
was
of
the
crazy and
dinosaur
absurd.
on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these.
This is the
Right
colloquy
now-
he
right
referenced
now,
earlier.
The charges against you, which are stated in the amended information, counts 1 through 6. The district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you. But I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense and could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you are, by having a lesser included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime, and you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you. They must find you not guilty. And they cannot convict you of more than one crime on each count.
And that's how it practically works out every time.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you have some kind of disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision. Any reason I should be concerned about that?
No, Your Honor.
Okay. Any other question anybody wants to ask on this?
Was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
So,
No.
He's wagging his head. No. Okay. Anything else before I accept his decision on this?
No.
All right. So I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone of the jury.
Guys,
I forwarded it along just for transparency reasons.
Guys, him objecting does not mean that
to the
he
defense
would
end of the court.
win that objection. He'd be objecting again, over the non-objections of his counsel.
I'm disappointed.
That does not mean he would actually win
I
those
didn't get it
objections.
yet.
The judge would likely just overrule them.
Well, wait a minute.
Why? Where's the motion for direct verdict? Where did
Oh,
that
yeah,
happen?
here it is.
We haven't gotten to there yet.
Is
All
that
right.
coming?
I don't know if it's coming today or not.
When would it come if not now?
Yeah, I kind of heard the opposite, and maybe I misheard it, but the way I heard it was that Kyle can actually force it if he wants to prevent lesser includeds. But maybe I misheard it.
Why wouldn't you do that?
I don't know. That's a good question. Because he's getting bad advice.
I mean, maybe I misheard it because I kind of zoned out in the middle
all
of
right,
it.
Thank you.
All right. So what's going on now?
Are we done? Is court adjourned? Are we not going to have any more discussion? Oh, we got a new player entering the stream. Just a minute. Let me make sure he doesn't. Yeah, this looks like court is adjourned for the day.
So we're not doing the motions. That's great. That's good.
Where's
news.
the
Hey,
directed
Hoglaw's
verdict?
here. A new participant.
Welcome to Hoglaw.
Yeah, that's about right
Hey.
for my timing, right? No, thanks for inviting me.
It's over,
Yeah.
Hug. We're retiring. Yeah.
Well,
I should have
thanks for coming,
invited you
everyone. Have a good
earlier,
day.
but
Well, no,
I
it's just me tweeting out every 3 seconds when something happens as I try to get over this cold.
I
but,
saw you tweeting and I was like, oh, he's watching. I'll invite him on. Well, welcome to it. What are your observations of the day?
Well, I mean, I think the main takeaway was the one that you guys made, I think, very well, which is I don't think the defense ever really got around to the big deal with the visualization there, which is, Your Honor, you sat in front of this TV we rolled in for however long it was, 20 minutes, with a pointer, and this is a capital case. Do you think the jury can actually hit a burden of beyond a reasonable doubt with what the state is saying on these kinds of things? And I don't think the defense ever really got there. And I was as surprised as you were to have them say, we've hashed it out long enough. Do what you will, Judge.
Yeah, that was baffling. And in my opinion, they had the winning side of the argument. And you sit there, and then when you consider that even worse, a couple minutes later, they argue that it would be improper for the jury to have, they state that the jury it's against the law for the jury to have unfettered access to replay the video over and over and over. And it's like, Judge, like we were just doing at the TV a second ago, and you're including an instruction based on you seeing the same video 15 times in a row with someone directing it with a pointer. And they're saying that that'd be improper for a jury to do so. Why are we including an instruction based on that? It doesn't make sense.
Yeah, and I don't know whether the judge has been chastened by some of the coverage he's gotten on some of these points, or whether this is just his modus operandi. Anything remotely controversial sent to the jury. I know a lot of judges work that way. But yeah, I certainly understand the consternation. And as I was tweeting out, certainly if you get that provocation finding, which already is a word that I think we as lawyers read differently than fact-finding jury members do. Like, what is provocation, right? There's arguments on Twitter half a mile long about the fact that him showing up in Kenosha is provocation. That's obviously not the standard here, but in a jury room, I mean, you just don't know.
So I was under the assumption they'd be arguing their motion for directive verdict today, or their motion for mistrial, but I guess that has not been submitted yet. Do you know anything about that happening or not. It's hard because you can't follow the filings in Wisconsin very easily. Anybody know anything about that one?
I just hope they're doing it.
And they said they were going to file the mistrial. So you'd hope they'd file the motion for dismissal, because even though, I mean, I think they lost on some of the evidence things today, that's a different question than whether or not the state has adequately raised to the legal standard required in their case in chief, that they've raised the issues. So I'm with Joe, and what he's been screaming is like, they've got to file the motion, like they have to do it.
They've been so passive throughout every stage of this, in objections, in following that and raising that motion at the close of the state's case. Today, I would have walked in there saying, "Why are we talking about jury charges? We should be talking about which charges are going to remain, because if any." That's how I would have started. They're so lacking in any sort of aggressiveness on his behalf. Even like I said, it was painful to watch how Binger got to badger him, and with zero objection. It's almost as if this kid has been stripped of his right to counsel. I'm speechless. I'm apoplectic. That's the word. I'm apoplectic.
I feel that.
Yeah, they started off getting some early wins on jury instructions, which were great to get, or not on lesser includeds. Things were going well, but they lost at the critical aspects of today. I mean, the critical elements that they had to hit. That provocation instruction should not be in there. There is no evidence in the record, and the evidence that is in the record is improperly in there because the defense failed on those issues, except maybe the blurry picture. But their failure to connect that blurry picture that the judge just told them, I don't see anything but a blur, and say, that's from the video, judge. They're asking you to look at this and just with motion pretend that you see something. How they don't say that is mind-blowing to me.
And because of that now, and because of this, okay, so you have ridiculous lack of foundation still shots, right? I mean, there's lack of foundation because they never said that it fairly and accurately depicts. So you have evidence that comes in that should not be there. It's basically nonsensical evidence, which a lot of it, with the whole thing with the left-handed, it looks conflicting, and we have no way of knowing if Rosenbaum even saw him moving the gun, if he was even looking that direction or looking for that millisecond to his left and didn't even see him do it. Then
they couldn't even think. Sorry, go ahead.
And we don't even know that Zeminski's not in the frame, but somehow the state, despite any testimony, there was zero testimony that Kyle waved a gun at anyone. Zero witnesses coming forward saying Kyle waved a gun at anyone. All of a sudden now the state is going to get up there for 2.5 hours and start saying how Kyle should be stripped of his right for self-defense because, hey, we know we lost on self-defense. Anyone with half a brain realizes he had self-defense, but he should be stripped of that right of self-defense because he provoked this whole thing. Now, all along, what does the state know? They know that for the last 14 months, every narrative that this jury has been hearing is Kyle provoked them by showing up with a gun. Now, based on this ridiculously altered, lacking foundation evidence of a picture and a ridiculously baseless narrative that zero people have testified to other than Humpty Dumpty there himself. But no one's got up on the stand. So we have ridiculously altered evidence. No one's sworn to that it's actually reliable at all. And you have Humpty Dumpty making claims as to what the hell was going through Rosenbaum's head, even though there's zero reason, no one's testified to it. No one saw Kyle waving that gun around. So now what's going to happen is they're going to have a provocation charge. And what happens to the mind of the jury that has been saturated on the notion that Kyle provoked them by showing up with a gun that night? They are going to hear that provocation charge, which is really only limited to that waving of a gun in a millisecond there that nobody thinks really happened, that maybe he waved a gun. So they're going to hear this whole provocation charge that the state is only able to get in on fake evidence with a fake narrative. And now they had this whole provocation charge. So in the minds of the judge, they're like, yeah, well, we kept hearing for 14 months how he provoked them. And the judge just said, if he provokes them, well, in that case, he loses right to self-defense. or whatever self-defense he did. So now the state just salvaged their case, which they lost for the last week and a half, because basically, in the minds of the jury, they're going to take the provocation they heard about him showing up with a gun and attach that and say, well, I guess if he's provoking that, if that's one form of provocation that strips him of his right to self-defense, so too the provocation of showing up with a gun and strutting around there like CNN and ABC News and MSNBC has been telling me for the last 14 months that takes away his right to self-defense. I guess the judge is telling me that they're all right. It takes away his right to self-defense. And this really is a ridiculous basis that this kid's life could be destroyed because of a fake evidence and fake narrative and the fake lies from mainstream media. And it's sickening display that America had to watch this corruption of our American judicial system.
Joe, tell me how you really feel.
Yeah, I was about to say the same thing. But I mean, it's criminal that the Richards and Sheriffisi do not recognize that this is the linchpin of the state's case. They've been arguing this provocation by association argument the entire time, and they're fighting on the provocation thing, and they're giving up at this crucial time. And when the moment they say, where's Zeminski, or judge like, where's Zeminski in here? And he's like, well, we think he's behind these lights. Judge, they can't even point on their best evidence where Zeminski is, and we're supposed to believe that Kyle pointed a gun at him. What the hell are we doing, Judge? Sorry, Nate, I didn't mean to cut you off.
No. I'm going to say it. This is all the defense's fault for putting Kyle on the stand.
Yes.
Because the first time we heard about this was when they put Kyle on the stand. They offered it up, and that's the first time we heard about him pointing a gun at somebody. If Kyle doesn't take the stand, we never get any evidence. And this is the reason why we all said in unison, why are you putting the kid on the stand? Because it can only hurt. It cannot help. And now it has helped in spades. It has recovered a dead case. This is why you don't put him on the stand.
This is lawyering, though. It's the lawyers screwing it up. It's not Kyle. Kyle was masterful. It's the lawyers not being good advocates.
Yeah,
it was a bad decision. I'm not all following that. It's just that it's the reason we're where we are is because they completely suck at every stage.
Yeah,
Well,
and what,
the judge
what I
shouldn't
think
have gone along with that. That's just, I think he's just afraid of what people are going to be saying about him if he takes some strong stands and says, hey, listen, you guys have to follow the law. This
right.
evidence is garbage, and it doesn't get us to this instruction. So, but he doesn't want to do that.
that's what the defense had to say when he said, do you have any further argument? They needed to say exactly what you just said. Judge, you sat there. I sat there. I don't know about you, Judge. I didn't see anything on the video. They couldn't tell me where Zeminski was. There's no way they could tell me that he pointed the gun up in any direction, much less at an angle towards Zeminski. We have no idea what movement is going on, Judge, or at least I don't, right? I guess you take that back upon yourself, and I watched it just as many times. There's no way this gets us to that instruction. They had to say it, and they just didn't. They let the prosecution finish, and if the judge gives you an opportunity to argue and counter a point, most of the time you should at least say something.
Unless it's
Not
so
always.
clear that you've won, and it wasn't there. Like the judge was still thinking about it.
Yeah, the second he says, show me again, that's when you know, I've got to counter this. Why does he want to see it again? Two things. One, you either want to reinforce the fact that he knows he didn't see anything, or two, you have to understand that maybe he saw something that he didn't see before. And you have to point out, Judge, you're watching this over and over and over again. He's telling you what's happening, but he's testifying. That's what they did in court. They testified to the facts of this. There was no witness there. They could have called one. They could have called Zeminski, and they didn't do it. They didn't have to do it. They chose not to call Zeminski, and we have no foundation that he pointed a gun anywhere. And they just didn't do that. And I'm sure Fisi's been very sharp for much of his appearance during this trial, and I think that was a critical failure to not continue the argument.
Potentially.
It's what I miss.
Apparently we missed the provocation instruction getting into the charges, and me one step from blackpilling again.
Yeah. The long story short is the provocation instruction is coming in. And at first, and this is the other thing, at first, DA Lunchbox, as Posobiec is calling him, is saying that their evidence for the provocation instruction is the picture, the blown up grainy picture. And then the judge's like, that just looks like a blob. The judge boomers his way through talking about how he saves screenshots of text messages, emails them to himself. And then when he tries to pull up the picture on the email and he blows it up, he can't see anything. He makes the argument that the defense was trying to lead him to yesterday. He figures it out on his own cell phone. And
he had his own epiphany, right? He had his own epiphany
Right.
moment, and they still couldn't capitalize on it.
Yeah, and then the state goes, oh wait, well that's not our best evidence though. When they realize that they've just gotten hammered into submission on this, and then they're like, no, it's this other video. Then they show the other video. The judge's like, I don't see shit. And then they're like, whoa, it's the slowed down version and the zoomed in one, and you just need to go back, and all you have to do is say, Judge, that's the blurry thing you saw, just stopped. That's the exact same thing. It's from this video. That's what they're trying to show you. And they're just trying to fool you with motion that you see something, but you know you don't see anything because they picked the best possible frame and gave it to you, and you can't see it. And they just couldn't say that goddamn argument. And I'm so mad about it.
But you know what though? I don't think it would have been a winner though, because that's you're making a factual argument at that point in time. And my response to that, if I'm the prosecutor, would be that's for the jury to decide, right? If you're saying it doesn't show what it shows, we're making a factual argument, and that's why we have juries. The juries.
But the argument is really it can't show what it needs to show at the standard that it needs to show it at. Let's say jury comes back with a piece of paper, says, we found it on this photo, and this photo, and this photo. If you're the finder of law, you're the judge, you say, I can't look at that and actually say that people can come up with that. And you put it in the jury's hands, you're risking that every time. And I do think we got a preview for what a directed verdict motion would look like, for what a mistrial motion would look like. I think this judge is conservative, not politically, but in terms of how he treats a jury, and is going to be disinclined to do anything on the massive side of the scale that would get him in Newsweek again or anything like that. So I think you're getting a preview of, if in doubt, send to the jury from this judge. And that's not unusual for judges. I'm not
I agree.
Place.
Richard, I agree with you that the judge doesn't want to go out on a limb. Very few judges ever want to go out on a limb. But at the same time, they have to make the argument so that if he denies it, they preserve the right to appeal. Because when you have a witness, the guy who is being charged with aggravated assault or attempted murder by shooting up at Gage Grosskreutz, and Gage admits on the stand that he did not fire at me until I pointed my weapon at him. Boom. On that charge of attempted murder, right away, that one has to be dismissed. That's how, at least get rid of that one. Knock them off one at a time. Knock that one off and let the judge say, no. A reasonable jury can still find that he was not acting in self-defense. And then with respect to that, that's appealable, that the appellate division will look at that and say, how the heck could any jury possibly come back with a
but that's what also makes provocation so important, right? Because he gets kicked into the different levels of, I need to exhaust every possible situation. And if you get that provocation finding, you're going to have trouble with even those obvious statements from the witness. So I mean, provocation was the linchpin. I think Nick said it right.
And to give a mild pushback to Nate, I agree that it could be construed as arguing facts, but when you've got the judge, and I don't know if you saw this, but the judge, they said, we showed you yesterday, right? We showed you the pictures yesterday, and the judge said, and I'm not even going to tell you what I thought about it. And he says those words, like, you're arguing facts at some point, but you're also arguing to and the judge said, when they said, he's like, you are asking me to add an instruction because the evidence clearly shows that this instruction is warranted and I don't see it. That's when you're like, no, you got to latch on to the judges. The judge already knew that this was wrong, and you got to go back. But the defense just went,
You're right. You're right.
And it's like,
and Binger has seen them do this 400 times, and that's why he knew he could push that Fifth Amendment thing, and the judge he'll fly off the handle. At the end of the day, he can always calm him down. He'll be like, don't worry, I'm sorry, it's all, you're right. And then they'll just start talking, and then the judge will calm down, and then he'll come around to whatever Binger wants.
Krause and Binger are playing good cop, bad cop.
That's true. But that gives
But
Kyle a lot
it's,
of
I don't know if
bites
it's
that they
good
ask
cop, bad cop, because the defense is nowhere to be seen. That's the problem. It's like when the only person you're hearing from is the prosecutor, yeah, he can play that game. Where's the defense reinforcing their objections? Where's the defense, as you pointed out, when they give him the opportunity to make another statement of, you couldn't tell from the videos. Where are we getting this from? It doesn't make any sense. And
making
all the
bad
rest of it.
arguments, right? Who was it that started to ask, is pointing a gun even a problem while they're having this out as part of the photo? It's like, what are you doing?
Richards, that was the other thing. Sheriff Easy actually was, he was I think he was kind of doing okay and rehabilitating what's going on. And Richards like, well, is it even a problem, Your Honor, for him to, is that actually provocation? Like raising it. Richards, are you going to, raising a rifle at someone absent some justifiable circumstance is provocation, probably. And yes, even if he points it at Zeminski and Rosenbaum sees it, Rosenbaum did threaten Kyle earlier, even though the state's like, we don't buy that argument. It's like, it doesn't matter if you buy the testimony or not, you're not the finder of fact. But even if he did make a threat, the jury has to determine that threat is still valid and that,
we feel your frustration, brother.
Sorry.
We feel it.
I know.
This defense fucks up. Yeah, we feel it.
And they fuck up at the critical parts. They're winning on the little stuff, and then the critical shit comes around. It's like, oh well.
They put the kid on the stand. They do this. They're doing all the bullshit. I don't know what's wrong. It's like they're trying to throw the case. I don't know what's going on.
I'm guessing it's over. It's like they're panning around the courtroom right now and nothing's happening.
We keep seeing them, like, this is the frustrating thing, is we keep seeing them march down the field and move the ball down the field. And when it comes time to score, it's like all of a sudden they just start running stupid. They just basically go into some different mode and they just get stomped. And it's very frustrating.
So I'm just thinking back to my first ever trial. And this is, I'm an articling student. I don't know if you guys have the same thing where you do sort of a year of training before you become a real lawyer.
Shout out to the AV guy. Sorry.
I had this case and it was a really good sort of rights violation case. And eventually sort of one of the senior lawyers came in and just said, hey, I'm going to rip into you because I don't think you're taking this seriously enough. You're coming in there and you think you've got this great case. You're underprepared, and yelled at me. And I was like, so I had to go back and look at it. And that trial was a lot harder than I thought it was, notwithstanding the fact that I had great facts. And if I hadn't been yelled at like that, I probably wouldn't have won. I had great facts, but it was a lot harder than I thought it was going to be. And I'm wondering, like, do they not realize that they still have to fight even though they've got these great facts? It's baffling to me. And I learned this lesson like, this was 8 o'clock day one in training. Sorry, go ahead.
No, I'm sorry. I think with this, like, a little delay. It sounds like you're talking about the Arbery, the Arbery case. Now the judge won't even let them call Arbery a jogger, because they said there's no facts that he's a jogger. Like, that case has just been blown up like crazy. It's unbelievable.
I saw your tweet about that.
I thought the defense was winning. Are they not winning anymore?
No, it's the prosecution that's winning, but the
because I thought you at some point said, maybe it was yesterday, said the defense was like winning or something. Maybe I'm having a stroke.
They're destroying. They're destroying.
Okay, never
Matter
mind.
of fact, you know how bad it is, how bad the Arbery case has gotten now. Before, remember the McMichaels were just this racist duo who just saw a black man running and chased them down and killed him. Now we know more facts. One of the biggest facts is that the police actually had McMichaels and the rest of the neighbors get their guns, pull them out, and search the house for Arbery because they believed Arbery was a burglar. And
oh my God!
They believed Arbery was armed. And it's all on body camera where the police officer is pulling. And they asked, "Why'd you pull out your gun if you're looking for somebody who's not done nothing?" They said, "Because we believed he was armed, and we believed that we were searching for a burglary." And that's not even the kicker. When the prosecutor tried to call Arbery or listen from the witness that Arbery was a jogger, there was an objection. You can't call him a jogger because there's no facts that determine that he was a jogger. The judge sustained it. There's no facts that he's a jogger. You can't call him a jogger until you got facts that he was jogging.
There are bases to question there are bases to question whether or not he was jogging at any point before he was. Because there's video of him walking into the community where he's just walking, he's not jogging. Now, obviously, a lot of that doesn't mean he wasn't jogging, because a lot of joggers aren't
Sometimes
running
you take
full
a break
time.
to walk.
Yeah.
I understand. So if
maybe
you're
you
running
do,
a long
you
distance.
cowards. No, I'm just kidding.
Hey.
I'm kidding. I'm joking.
Jog-
I'm joking.
Let's understand. Jogging to somebody's house 5 times in the middle of the winter with no shirt on. That's a little, I don't think
weird.
It's really weird. It's really weird why he doesn't wear that shirt. I don't understand any motive that's normal or that's nefarious or malignant or benign that for him to be walking around with no shirt. Like, I don't see how that's not something a criminal does. It's not something an innocent person does. I don't even know how it's relevant. It just is weird. Am I the only one who has that question?
The question was Mr. Arbery, did he look suspicious to you in some way? I'm not quoting it directly, but it's, was he suspicious? So they asked it to the homeowner, and the homeowner, he was like, no, Mr. Arbery's a good guy. So like, he wasn't suspicious at all. He was like, so he wasn't suspicious in the middle of winter with no shirt on in your living room in the middle of the night. And
You know
that's when
what
it
would
came
be
out, yeah, he was a
suspicious?
little
It's if
suspicious.
it was the middle of summer and he's wearing a parka. That would be suspicious.
Right.
Yeah.
Like it's but him wearing fewer clothes in winter is less suspicious, because where is he gonna hide anything? Like I don't understand that logic.
I'm wondering, because here's my confusion. Long crime is still up. I'm wondering if we're on lunch.
It seems like it.
So that
maybe when we come back from lunch, they'll make that objection they failed to, and it'll all be better, and I'll be happier.
So what are we expecting to happen now after this recess? What are they going to be up to?
I would, by performance so far, I expect the lawyers to just walk in and stipulate to everything.
Yeah, I mean, what we're waiting
Your Honor,
for.
we want to call our client a white supremacist.
Your Honor, we agree with the characterization that he was there hunting black people, Your Honor, but he just wasn't able to find anyone, so he killed white guys, Your Honor. We think that's a fair stipulation. I think maybe, I mean, the judge had said, jury instructions and motions. So if they do have a motion to dismiss or mistrial,
please,
then maybe we'd hear something. You'd expect something to come out of this. They're gonna file it. I just would expect them to file it today, since Monday is closing arguments.
Nick, I think the only hope that they have today, as far as a motion, is that mistrial on prejudice. Because if you're bringing in the provocation argument, then how in the hell can you stand up and say that self-defense saves you from everything that's happened right now?
Yeah.
Because I mean,
the
provocation. If they'd gotten the provocation argument thrown out, then they could have moved for a directed verdict on everything based on the evidence of self-defense, and we'd be done, gone, get out of here.
Yeah, but now there's a question of fact for the jury to find out about provocation. It's the critical error. It's so bad.
Yeah, if you're the defense, I don't know why you even bring up the word provocation, even though that's something you got to fight, because that's a linchpin to your self-defense claim. But I don't think this jury's. I think the jury's smart enough to see through all this, right? The jury sees. Well, if they were watching what we were watching, it's like, really.
I mean, crazy things can happen
out.
with a jury, though. Crazy things can happen with a jury. Like how we. Was it here? Was it on this stream, or was it on Eric Hunley's stream? I don't know. Everything is blending together this week. But I mean, you can have a jury that is given a photo of a crime scene and something that is not even admitted into evidence, but they attach a significance to it and completely derail the entire analysis that with questions that weren't even brought in at trial. So many things can happen with a jury that you don't anticipate, because human brains work funny sometimes.
Right. I would even go a step further and say this, though. I think the defense needs, and they've never, I doubt they're going to do this because it goes against their nature. If they're not going to object at trial, they're probably not going to object in closing arguments any. But, I've heard people advise me over the years, you need to object every single time you can in closing argument, just so you can get the prosecution off their game. And given that these boys have gotten a lot of leeway in what they're allowed in, I wouldn't be surprised if they tried to make those inferences, the broader inferences about provocation, about him coming with the gun, even though that's not within the limits of the
That's coming.
instruction, they're going to try to
Absolutely.
do that in their closing. So
Damn straight.
so
Yeah.
so the defense needs to be sitting up ready to object every other sentence, and if that eats into all their time, then so be it.
And
The problem is relying on the defense to object to anything in this trial is like, I mean, it's like relying on the government to lower taxes. It's
if they're halfway smart, they can do it without raising an objection. They just have to bring in all the predicate. He came down there that night. He brought the firearm into this dangerous situation, some more stuff, and then they say, now you're going to be constructed on provocation. So without actually tying the two together, by just juxtapositioning them, you can get the jury to draw the inference. You're there.
I don't think they'll rely on the jury being that smart. I think that they're going to try and tie the two together thusly. They will play into what the media has been putting into this jury's head, and they will say he showed up that night with a gun to provoke them. He's running around with that gun to provoke him. They will paint everything he's doing there then he went over to Yellow Pants and provoked him with a gun. You even heard that he admitted that he said it to him and said, yeah, I did it, because his whole objective that night was provocation. And then finally, when he's running there and he's chasing after Rosenbaum, according to their stupid, ridiculous narrative, he chased after Rosenbaum to provoke him. And then when he turns around on him and waves a gun at him and he provoked him, and finally Rosenbaum snapped and charged at him, and then he mowed him down and wants to say self-defense.
Yeah, you're exactly right. You're exactly right, because I was making the very foolish assumption that there was a good defense attorney who would be objecting to literally everything you just said, but of course that's not going to happen. So you're absolutely right. I'm sorry.
Yeah, and that's and when you paint it like that, the jury's gonna be like, wow. I guess and now the judge is telling me if he provoked them, in that case, it doesn't completely strip away self-defense rights, but it abrogates them.
Can we just go down to the local law school and just get whoever's on the mock trial team to do this? It'll be better.
I'm going to bring another lawyer into the stream. Someone who
please help us.
I have not. I've not had the courtesy of meeting before, but this is a Mr. Daniel Turkley, I believe. Is that how you pronounce it?
Yeah, you got it right. Very good. Very good.
All right. Well, welcome to the show, sir. Can you give us a little bit of background on you so the chat and the panel know who you are?
Yeah, absolutely. So I'm a criminal defense attorney in Middle Tennessee. I happen to be licensed in Arkansas and Missouri, but based off what I saw today, I'm going to go ahead and add Wisconsin to that. What I noticed today during that charge instruction was something I've been railing about forever in regards to lesser included charges. I've said for a long time that defendants should have to consent to those lesser included charges. And that's kind of what we saw today, where Rittenhouse had the option to go along with his lawyer's recommendation, or possibly even to object and preclude the state from bringing those charges or having those sent to the jury. I think that's incredibly essential to stop overcharging, in these cases. What we have in Tennessee, where I deal a lot with cases that are just objectively overcharged, is the state gets saved by these lesser included charges and have the option basically to take a free shot at somebody on an enhanced charge and have the jury come in and fix it. So to the point where, as a defense attorney, I might be in a position where if I win the trial, that means my client got convicted of what he was supposed to have the entire time, instead of him having been discharged appropriately and having made a deal from there.
Daniel, I practice in Middle Tennessee some also. And I had a jury trial a few years ago, and sometimes on the drug charges, they'll have possession with intent to sell or possession with intent to distribute. And you'll get that dual indictment on the same charge. And it sometimes is confusing as all get out, once you're trying to sort out what you've got at the end. I mean, have you ever had a situation like that where it's like they double charge on multiple theories of the same, and then they merge them at the end whenever they have a judgment?
Well, yeah. So let me let me touch on that. So we had a trial in Smith County just a few months ago. That involved two counts of attempted murder with a single bullet having been fired. Okay. And nobody really knew where that shot came from, but that's kind of neither here nor there at the moment. But But if we had the power to tell the state, prove what you charged or get nothing at all, then it's an entirely different case, as opposed to no, go ahead and go to trial, take your free shot, and then hope the jury comes back and and saves you with what it should have been all along.
Yeah.
Yeah, PBS has the trial in recess and will resume shortly. One thing I'm half watching on the other screen. One thing that I also saw is they have the little bingo turner presumably for jury selection. So that may
Do
be.
they really have it in the courtroom? That's funny.
Yes, they do, and I just saw a lady come up and gave it a few turns to make sure it was working. So it does appear that they may be coming back.
Nice.
Quick question.
The other thing Matt was. Go ahead.
No, I was just going to ask a quick question. Did I hear right yesterday what they do? So there's 18 jurors or 15, however many jurors, and after the trial, then they randomly choose what 12 are actually going to deliberate. Is that the way this works here, or do they have because I know usually you have the 12 that are on the deliberate, and then you have 4 or 5 alternates. But here it seems like there's no alternates. Everybody's like a proposed juror, and then they have like a random selection at the end of the trial.
Well, you don't want people snoozing, right? You're trying to make sure everybody's paying attention. So this is a way to do it.
In Mississippi, we actually pick the alternates to begin with, but in Tennessee, we do like we do here. You pick 14 people, or however many that the judge selects, and then at the end they draw a hat to determine who the alternates are, and then if they weren't used, then obviously they leave at the end of trial.
Yeah, I think the concern is if you're an alternate, you're designated as one that you might not pay as much attention. I don't know whether it's warranted or not.
Yeah.
Let me ask you: if you were an alternate, would you be paying as much attention? I wouldn't be. I think it's a logical move. I think it makes a lot of sense, actually.
I mean, there were portions of this trial that were nap time, even if you thought you were going to be called to it. So if you were an alternate, you'd probably just throw out a cot. And
lawyers like to hear themselves talk, don't they? My goodness.
What are you talking about?
There's a question from the chat that should just be addressed real quick, because it was addressed in court if you missed it earlier, but they asked if the jury would have access to the videos to review. And apparently the law, at least in Wisconsin, is that if the jury is going to review video, they have to do it in the presence of the court. So they have to come out of the deliberation room, do it in the presence of the court, and then return to the deliberation room. Both the judge and ADA Krause disagreed and thought that the jury should have unfettered access to video. But when Krause requested some opinion on that, the opinion came back, I think from the DOJ, that would be reversible error to allow the jury unfettered access to video. So the answer to the question is the jury would have some access to review video, but that would be tempered by the court allowing them to review the video a limited number of times. And the worry would be that I guess the theoretical worry is that they would watch the same thing over and over and then maybe see something that isn't there eventually. Or I mean, that's the theory behind it, whether people agree or not. That's what the court determined.
Well, I mean, we saw that happen in real time with the judge on the.
Yes, we did. We did see that happen, and that's the concern. Matt, what were you asking?
I was going to ask, are they going to be doing? I guess they would have to do that in open court. They bring them in, convene them, sit down, watch the video however many times they need to, and then they leave. I mean, that's kind of how we do it down here in Mississippi.
Yeah, that's what it sounded like from how they were describing it. So I would assume that it would be open to the public. Which is weird then, because does that mean that if the judge said he had a trial starting Monday, which is obviously going to get stayed, does that mean that they have to keep the trial room available, the courtroom available for the jury to deliberate over video? So does that mean it could push the other trial back significantly?
I would think so. Unless they've got an extra courtroom somewhere in the basement.
If you were defense counsel, would you want the jury to have unfettered access to the?
Hell no.
God, no.
Yeah,
not with the shit video evidence that they have.
Yeah.
Here's what's going to happen if they do. One juror is going to see what the prosecution says.
Yep.
And then they're going to watch it over and over with him doing the pointing thing and see. And then he'll convince people that the big blurry blob actually is a UFO.
Yeah.
Not to mention the fact that I missed this during the trial because of how the videos were introduced and the absolute trash foundational job that they did on every one of these videos. One of the videos has circles and it says Kyle possibly pointing his gun at Zeminski. It has hearsay
I missed
testimony about what's happening. And that
Wow.
was allegedly introduced by the defense.
That's as admitted.
As admitted.
This is the worst defense ever.
And I mean, I don't actually remember the defense introducing that video because of, again, like how confusing the introduction of evidence was here. It's who are you? I'm a cop. I looked at videos online and I determined that they're real. And so here they are. Let me now testify to what happened in those videos is the most ludicrous thing I've maybe ever seen in my entire life. But that alone. But then, yeah, so apparently the defense introduced the video with the annotations. I don't know that we saw the annotations, but they're in evidence. And wouldn't be objecting to their own annotations anyway. And they would, hell, let's be honest, they wouldn't be objecting to the other party's annotations either.
They probably didn't even realize they had the annotations on there sometimes.
Well, that does happen.
I know we've talked a
true,
little
yeah.
bit about the ineffective assistance of counsel appeal and how hard that is, but the more and more I watch, the more and more I'm thinking, yeah, that's looking like a pretty plausible theory of appeal at this point, among others.
Well, if those are the defense annotations and they submit that's ugly.
That could be a
That-
stipulation.
It's
That's
just one
appealable.
more thing on the
That's
camel.
appealable error that's appealable. I'm saying as far as ineffective counsel.
Yeah.
Yeah,
This
but that
is
would be a
one more
collateral
thing.
attack, wouldn't it? I mean, you'd have to go through all the appeals first and then
Yeah.
do a
Before you
PC.
get it.
Maybe I should just start writing the appeal. To give
So-
myself something productive to do.
So then Kyle would be in jail for a significant amount of time, well before they
Yeah.
ever even get around to the issue.
Yep.
Well, and somebody famous like him is going to not have a great time in jail because either they put him on his own, so he's alone in there and going slowly crazy, or somebody takes a run at him is another possibility.
Yeah.
So I don't like that thought at all.
Me either. I'm very disheartened by what happened today. And again, it's not the state attorneys did not do a masterful job. The defense attorneys did
No.
a poor job, and that
To be fair, the state attorneys were more competent, have been most of the time. I mean, they diligently kept fighting, which is what you would expect them to do.
Yeah.
I think that they're lawyers. I think that they submitted evidence that they know is BS and made up some crazy narrative that I think that Krause actually believes has some sort of legitimacy. He started saying, well, when he's saying gun, 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 he's warning everyone about that Kyle's threatening them. Yeah, that's what happens. Someone fires off a gun in the air and a guy screams gun, gun, gun afterwards. He's probably talking about someone else as opposed to warning the crowd that, hey, there's been gunfire here. But that's what he's going to try and sell to the jury. And, we always feel like, let's try to read the jury. We have no idea what the hell the jury is thinking. We have no idea what they look like.
Nothing.
We don't know anything about them. We don't know what gender. We don't know there's no way to read a jury. We're not. If you're sitting in the courtroom, maybe you could read a jury, but none of us.
No, it's human beings all the way down. You never know what they're going to do.
Yeah.
And I think that's the problem with, you talk about ineffective assistance as an appeal route. I think that's true. But just talking about it on a more kind of platonic ideal basis, the problem with bad representation from the state, bad representation from the defense, is you're getting further and further from what anybody could logically describe as the truth of the situation as it happened on the ground. And it's become this kind of morass of screw ups from both sides. And that's the pity. I want the guilty to be punished, the innocent to go free. And we're so far afield from what the hell happened because you've got all these stories coming from the state. You've got screw ups on the defense side with respect to objections. And, I wouldn't want to be on that jury sitting there right now because you got a whole mess in front of you and you've got instructions that aren't going to match up with necessarily what you even think you've been shown. And human beings are those human beings, and jury trials are a crapshoot.
It can be. With these instructions, certainly.
We know a motion to dismiss some of these charges has to come because the judge is right. I keep saying has to. The judge is right there on the minor in possession charge. And if they can get that dismissed, prior to jury deliberations, then they have to. If he's
Yeah,
not
something that-
illegally carrying, if the judge can come in and say, actually, we've dismissed that because he was not illegally carrying a gun at that point. It may be the thing that sways. One juror says, well, he shouldn't have been there illegally carrying. And they're like, I wish he wasn't there carrying a gun, but if it wasn't illegal, I mean, that could be the linchpin or the new one. I mean, oh God. I'm
within the
yeah.
within the instructions, there was no instruction that explained that even if he's illegally carrying a gun, that doesn't really weigh into the self-defense claim. Like there's no language like that. Like even if you find that he's illegal, that the gun was illegal, that he still has a claim of self-defense.
I think they can make the argument on it, but there's not a jury instruction on it.
Has Richards ever won a case?
A lot of people have asked. I think Barnes suggested he had not ever won at least a big case. But I don't know that, like I don't even know that Barnes actually suggested it. That's what I heard someone else say. This is hearsay testimony. Okay. This is hearsay.
Well, yeah. I actually heard
I'll
Barnes
take it
say
from
it. But
Barnes.
I heard Barnes say something to that effect, but or something to the effect of people who have big wins go around talking about them a lot, and you never hear him talking about any of his past cases. So I think that was his speculation, as I recall it. Although me saying that to you is still hearsay. So
he's talking about his what? He's still talking about his iPhone logarithm, right? How did he miss
Logarithm
versus algorithm? Yeah, like I have so many logarithms. The logarithm doesn't let me do it.
I'll give him a pass. That was the least of the problems.
Yeah.
I'll give him a pass.
Yeah, you can screw up logarithm all day.
Well, fellas, I have got to sign off for now because I've got to go pay the bills and people are blowing my phone up.
Good luck with your
stuff. And
good luck with your cases.
Good luck.
Good luck.
Nice meeting you.
Is there anyone? Is there anyone is there anywhere people can find you that I can put in the description of this video?
Well, my Twitter is @LawyerMatt. And
I will add you now.
I know you're getting added right this second.
And as far as YouTube, I have set up a channel. I just haven't posted my first video yet. I'm a newbie on this. I was about to start doing that maybe last week, get the equipment and that kind of stuff. And then I got hired on a very, very big case, and I basically abandoned my family for about 3 or 4 days and worked just on that. And I still got to get ready for trial and lawyering stuff. That's right. So if I showed you my YouTube channel right this minute, it would probably be embarrassing. But I emailed you the link, Nick. And if you want to see a nice picture of my Supreme Court admission picture, I mean, that's really about it right now. But subscribe and maybe when stuff happens, we'll throw you stuff. So
you said you
Supreme Court admission papers. That'd be good.
You emailed that to me, Matt?
I did. So I messaged you in response to your question earlier.
Okay, gotcha. I will add those both of those to the description.
And thank you for your hospitality, Nick. This has been a very, very good day. And I've enjoyed chatting with each one of you, and to the audience. I look forward to maybe coming back on other days, or if I'm invited, or barring that, if I have my own channel and y'all decide to watch, there you have it. So thank y'all very much, and
take care, Matt.
See y'all later.
See ya. Thanks.
Bye.
Let me get
So I got a question from the chat.
Guys.
You gotta go.
Yeah,
I gotta go pick up my kids. I'll see you guys a little later. I'll see you guys probably tomorrow. Well, not tomorrow, Monday or something. Take care, guys.
Yeah, Nate, I'll see you Sunday. Oh, okay, bye. I got a question from the chat that I want to ask. Someone asked, wanted to know what the panel thought as to who would prefer pro se to this defense team.
No, I don't think so.
No.
I'll tell you, I would prefer state appointed counsel to Mark Richards.
I agree with that one. I agree with that one.
Well, I said in other places, I'm actually curious if they had just rested after the prosecution case, whether they'd be further. I don't know that they moved the ball very far on their side of the equation.
Yeah, they may have actually moved it back a little bit, to be honest.
Wait, what was that? Sorry.
Oh, just that I will never know, right? It's alternative universes, but I do find myself curious as to what would have happened if they stand up after the prosecution rests and say we rest as well. And go from there. I just don't think they moved the ball very much.
And we had such a great flavor at the end of the state closing their case, and we don't have that now. We didn't have that even yesterday when they said we arrest. We didn't have that. So I've got to agree with you, Richard. They would have been better presenting zero defense at all than to like do what they did for the last couple of days.
I mean, because they had everything they needed out of Gage Grosskreutz and Richie McGinnis. I mean, that for the self-defense claims, you've got Richie McGinnis showing the Rosenbaum one. You've got Gage Grosskreutz getting Huber. I was scared for Kyle Rittenhouse because Anthony Huber was going to possibly cause head trauma with his skateboard. So you've got that. And then you've got him saying he didn't fire at you until you advanced on him, drew your gun, and pointed it at him, right? Correct. I mean, open and shut on those things, in my opinion. The other things you have are the reckless endangerment charges, which I think are relatively ludicrous. We've got Jump Kick Man kicking him in the face on camera and him firing. I can't imagine. I can't even believe that they're charged. You're stomping someone's head into the ground on camera, and we're going to argue that they don't have a right to self-defense when people die from that on the regular. So anyway.
Yeah, I think the one thing though that I could see would be a reason for them to still put on some sort of a case in chief is the jury. The jury also, I mean, how many of them have ever been part of a trial before this time, right? Most people's perception of a trial is, for better or for worse, is framed by what they see in movies and TV shows. So they may have had a concern over the idea that the jury would think, okay, if they're not putting anybody on, is that because they don't have any evidence? Is that because they don't have anybody on their side? So they may have been combating something like that. I don't know what you guys think about that possibility.
Well, there is still one. Yeah, there is still one more tactic the defense can use that would be analogous to not putting on a defense. After the state had closed, the defense could always waive their closing after Binger gets done with his first closing and cut off the rebuttal, and that sends the same kind of message. And frankly, would probably surprise Binger who's holding something back.
Go ahead. Did they call a ballistics or a firearms expert of any sort here?
I don't think so.
There was one. She was the lady who had the most insufferable cadence. She was there.
That was the prosecution expert, though. Yes.
Yeah, the defense didn't call anybody.
I completely zoned out her testimony, honestly, because of her cadence.
Yeah, she was a crime lab ballistics expert. Yeah, the defense should have had somebody because their argument. And again, the argument is being made, or the testimony is being offered by the prosecutors because they didn't properly object to the prosecutors arguing about the caliber of rounds and what they do. They correctly said Kyle's not an expert, but they didn't bring an expert. And John Black probably has the expertise to talk about it.
Also, if you bring a use of force expert, that could go a long way towards particularly establishing on the reckless endangerment that everything he did here was pretty much textbook as to what you would want a person to do in this situation.
Well, they had a use of force expert and they stipulated away his use of force testimony to get rid of Bob, which is a terrible choice.
Yeah, and I just think there's all these arguments about over-penetration and about him possibly switching arms when he's wielding a sling. And, I'm like, we need some evidence on this because it all goes for the defense if they actually know what they're talking about. And I'm worried that the defense they don't seem to have the background there and they don't seem to have the knowledge that these are actually live issues. When the prosecution is talking about, these hollow point rounds, they explode. Well, the judge is sitting there going, no, but they needed actual evidence to say, listen, that's not a thing. And what does it actually mean that it's a full metal jacket round? 223 rounds often break up even if they are full metal jacket.
Yeah, they're designed to fragment and tumble. They're not actually designed for penetration. That's kind of the interesting thing. But in the judge today, though, he says, wasn't he using steel jacket rounds? Yeah. So the judge has an idea about the ballistics, and steel jacket isn't. Steel versus a copper jacketed round might actually make a difference. I'm not an expert. I don't know. But again, this is going exactly to your point. Why didn't they have one? They have raised, I think, over $600,000 subsequent to the $2 million bail that they raised. They presumably have the funds to try this case with the best that you can offer, and they didn't.
I could have given them 40 names, just, and that's in the States. That's not even in my practice area, just of people that they could have called to say, hey, listen, these are, and I was kind of waiting for it, especially because there's so many arguments here. Somebody just sent me a message going, what about the fact that, it might be in his left hand? Well, wouldn't it be nice to have somebody who's actually used a sling on a rifle to say how much of a pain in the butt it would actually be to switch handedness when you've got it on a sling? How much time does it take to, get a rifle that is slung around your back? Because we see him carrying it in that fashion in some, how much time would this take? Would it actually be a one frame little moment, or would this be a more exaggerated gesture that you could see? All of these things I think could have been helpful. And everybody watches movies. Everybody sees, they watch John Wick and suddenly they think that they know guns. And the real danger is that you get police officers who do the same thing. They're like, I handle a gun all the time, therefore I'm an expert, and the court allows it. And lawyers who think that they know enough because they might have gone to the range a couple of times. I'm like, you don't know enough unless you've actually played around with ballistic gelatin, unless you've, or at least read the articles from people who have. Have you seen work done with witness boards to know about deflections? Have you, do you know what it means if do you know that different brands might actually behave differently and
different grain?
Oh, and bullets do weird things. I had a file where somebody was shot under the chin and you'd never guess where the exit wound was.
His anus.
Elbow. Because, and there's a case in the States where in a gas station robbery, they went and lined up people, shot them all in the back of the head. One of the survivors has an entry wound at the back of his head, an exit wound at the front, and it's because it hit his skull, tunneled under the flesh, and exited. All of these things you need people to be able to talk about when there's a reckless endangerment charge about what happens after you shoot through somebody. Mm-hmm. It's frustrating. And this isn't just a rant about this case. This is a rant about criminal practice in general.
But see, in a lot of criminal practice, you don't have $15,000 to pay that expert, right? But in this case, you do. That's the problem.
Yeah.
In this case, you have $50,000 to pay the best ballistics guy that you could possibly want. And
well, and it doesn't even necessarily start with the $15,000 conversation. It starts with reaching out, to somebody, even just the guy at the gun store is probably going to know more than your average lawyer, and just saying, can I have a chat with you? When I had cases about lock picks, I didn't know a damn thing about them. So what I did is I called some locksmiths and said, hey, I'm a lawyer. You just want to chat with me for half an hour? And it wasn't hard. There's lots of people out there who are entirely willing to have that conversation. And I don't think they did that. And it bothers me when I see these kinds of things. And when I see case after case out there where you get, these factual errors that creep in. I actually think that there should be sanctions potentially imposable. And I don't, it doesn't seem to be, when people go up and make representations to the court on technical points as if they know. As a lawyer, when they say, oh, it's just like a magnifying glass. If that turns out to be wrong, that should be sanctionable, because the lawyer's responsibility, if they don't know, should be to say, I don't know.
Like their expert did.
Yeah.
Constantly.
And the state got to testify, basically. Anytime there were holes that they couldn't put anyone in the stand, they basically would testify, and the judge would be like, okay.
Yeah. I mean, the state's been testifying the whole time.
And Kyle turns out to be a legal expert, too, because he's correcting the prosecution on the law relative to firearms ID cards in Illinois and stuff like that. Yeah.
But see, I've been here short enough that I think I can say this. This is why I think that what you're doing here with the streams and the commentary is so useful. I'm my show, Virtual Legality, focuses usually on tech and video games and that kind of thing. And I've been out there on Twitter with all the outlets talking about how dumb the judge is to not just accept that Apple Zoom In doesn't do anything to a photo. And you've got headline after headline after headline after headline after headline saying that, oh, this shows that the judge is biased or whatever you want it to show if you're writing these articles. And it's such a normal course that the court has taken here to say, well, I don't have to take it on faith that it's a magnifying glass, that you doing this isn't something. And it's so funny to me because generally speaking, these outlets, hate Apple. They think they're doing all sorts of weird stuff behind the scenes. So I think it's super important to help explain to people that this is the highest level of power that the state generally uses against its citizenry, putting people in cages, potentially doing worse in different jurisdictions. And the court wants to get it right. And you could disagree with the defense or the prosecution or even the judge, but them slowing down and saying, hey, bring in some testimony to authenticate this, regardless of how you felt about that testimony, is not some ridiculous thing that's happening at the court level. It's exactly what you would want if you were being tried for murder. And I think this stuff, being able to look in on a case like this, is so useful because everyone else is not doing that.
Right. And the thing too is that I wish people would understand that anytime we're talking about technology, science, any kind of like complex theories of anything, courts are not just going to assume that they know anything. They are always going to bring it in through valid experts. There is such a thing as junk science. That's why we have certain standards that they have to meet in order to be introduced as evidence, because they have to be reliable in order for a jury to even look at it. So that's the thing, is that it has to be filtered through a process so that the jury can automatically trust it when it comes in front of them. And that's
sorry.
I was just finishing up.
He's ready to go.
In an insurance claim case where you've got flooding in a house, they're not going to accept that you have 2.5 gallons per minute pipes based on the fact that basically everybody whose house is built after 1960 or something has 2.5 gallon per minute pipes. They're going to make you bring in a plumbing expert and talk about it. Because if you just try and offer testimony, well, how do you know that? Well, because I'm a lawyer and my house has it. Well, you have no idea. Like and so we're talking about interpolation of pixels on blowing up an image hundreds of percentage points. And the fact that they did not object immediately when the detective said, well, I used pinch to zoom on my iPhone and then I was able to see it, that they didn't object and say, Your Honor, are we serious here? We haven't reviewed the pinch to zoom. If he thinks he can see it, they can export it. They can explain how they exported it. They can present it to the court for review. This guy's just a cop with an iPhone, and he's going to testify that he saw Kyle Rittenhouse raise a gun because he pinched to zoom on his iPhone one time, and the jury doesn't get to see that. Just, oh, well, I saw it on my iPhone. Are you serious?
But we all have iPhones. We all have smartphones. So we all know how they work. We're so used to them all the time.
Right. Yeah. I don't know how anything in my house works. It's good that it does, but I mean, we're lawyers. So, the court doesn't assume anything. And yet it gets reported on, and obviously there's a narrative to go with all this stuff, but it gets reported on as how could the court block something as easy as you just zoom in and there it is. Gee whiz, we're pretty cautious about murder charges, guys. I would hope that you would want that for you.
I mean, you can argue that a screenshot of a tweet isn't authentic because it's been a manipulated image. And then they have to get on there and they have to prove that, as Joe has been hammering, it's a fair and accurate representation of the tweet. Right. And so, but you can then use that to try and cast doubt on the image all you want, but at least it'll get in because it's authentic. The crazy thing about this is we didn't have any testimony that the detectives made that any of the video was a fair and accurate representation of the video. He just said, I went to Twitter and YouTube and downloaded it. It's like, okay, what software? Did you download the whole file? Did anything get edited out? We have nothing. They should have rejected.
YouTube never compresses anything in weird ways. That never happened.
Oh, geez.
And we still don't even know where the drone footage came from. And their foundation for it was played on Tucker Carlson. And then we got a copy. It's like, so So, and the FBI drone footage, they apparently just decided to drop that. It seems like they stipulated to dropping that and striking his testimony from the record because they couldn't produce the HD footage. But again, they had that discussion in front of the jury. They already had the discussion about what was on the footage from the FBI guy. And it's like, object to this, object. They didn't produce this in a timely manner. It's prejudicial to your client. Object. I mean, and we don't know, to be fair, we don't know what objections were raised during that testimony, but based on history, I can assume none.
We
You
haven't
know,
seen
given
legal.
how bad it's been.
Sorry.
I'm sorry. Go ahead.
No, go. You.
I was just saying, at this point, given how bad the defense has just effed this up in every possible way, if Kyle does not wind up in jail for the rest of his life, it's only because some deity somewhere really likes him and is casting his favor upon him. I cannot believe with this. I don't know if the court's coming back or not. And if not, maybe we can go and rewatch the moment where this all went to shit. But where they're letting in this instruction about provocation. The jury is going to get lost if the prosecutor has any sense at all. They're going to get lost, and it's I'm back to all the black pills. Just it's all doom and gloom. I was so happy yesterday. How did I wind up here?
Right after the provocation moment, Kyle does the thing that that Kraus did a couple days prior.
Oh, that's good news.
He swaps it to doing his hair real quick. He realized he was face palming. Yeah,
but
no,
he can face palm because there's no jury there, so he might as well face palm at this one.
No, I did see that too. You could see him go, "Oh no, I don't want this." He's media savvy there.
Real quick, Bat Gamer Show says the Real Bat Store on eBay for your cakes and other special food. Over 700 plus item needs free shipping USA and international on all items. God bless everyone. And then
what am I going for
love
cake?
when people use.
I could use a cake right about now. Where am I going to order this cake?
Apparently, the Bat Store the Bat Store on the Real Bat Store on eBay seems like.
Okay.
Do you think that might be a Mr. Uncivil? You've worked in intellectual property. Is there a problem with having a store on eBay called the Real Bat Store and having a Batman logo as your logo?
If you have the Batman logo, yes, you have a trademark infringement problem.
How much modification of the Batman logo would be required?
All of it.
Well, enough that it would not be readily identifiable as the Batman logo would be super helpful.
615 base says this is one of two. Oh God, where's the other one?
I'm ordering cake.
Oh, I see it. I see it.
I'm ordering cake.
Says I think the most powerful moment was the tipping point in the trial when Backdoor Binger was bullying Kyle to tears, and Kyle kept saying, "I didn't want to do this." I think he was acquitted at that very moment. I would not be so fast on that one.
Yeah, I mean, if you've got LeBron on the jury, it's gonna play differently than it might to somebody else.
Yeah.
So, I mean, like that's a concern.
And if people aren't familiar, LeBron James was on Twitter basically calling Kyle a faker and various other things.
And he's not the only one. He's not the only one.
He's not just the most famous that I saw.
In fact, Michael Strahan interviewing Gage Grosskreutz asked the question in a very implied way how fake he thought those tears were.
A leading question. It was a leading question.
You could call it. Michael Strahan leads the league in footballs going through his teeth. 615 base says if you watch the live back at that point, you can even see big man Kraus wiping his eyes like he was crying. Look, I'm going to quote Louis Anderson on Kraus crying. Okay. He says, fat people sweat a lot. If fat people don't sweat, they explode. I'm not sure Kraus was crying at that moment. I think he very well could have been wiping anything off of his face, like maybe a sweat bubble, because that guy gets worked up really quick. But he says he wiping his eyes like he was crying because he realized how screwed up the case was. I'm serious. You should go watch that point in the trial. I've seen the video of it. He might be crying. I don't know. It's impossible to say.
The thing is, though, is that if you weren't crying, and even if you were, you'd want to just grab onto the desk and just or just get up and go to the bathroom or something, because that's such a bad thing to do in front of a jury. Michael
Smith says retired Army vet. I'm right-handed, so in order to use my left hand, I would need to remove the sling off my right shoulder and put it on my left shoulder. As far as sliding weapon around to your back, that takes mere seconds. No, you're right. If only they had someone experienced in AR-15 usage with slings, that could have testified to it. If only they had John Black there, who has all sorts of weapons training and a 42-page CV on being a firearms instructor, could have maybe talked about that. If only they had done any of that, and not just given up his expert testimony at the Dober hearing, we might have seen it. We might have seen it.
Yep.
If you're going to give up him as a use of force expert, you got to hire someone else to handle some of these things, or just not bring Kyle to the stand, because all that all came up when Kyle was on the stand as well. But
It's almost like they couldn't see what was more than like 30 seconds ahead of them in the trial. That's really what it is. There's such lack of foresight, such lack of recognizing what was going to be coming down the road. This is really painful. This is really, really painful, because I'm like you, Kurt. I came into today thinking like this was an easy win. I was saying last night that a mistrial is a loss at this point, that we should be hoping for acquittals across the board, and that a mistrial hung jury is a loss. And now I'm sitting here thinking and that there was zero chance that 12 people would vote to acquit. And in the wake of today, I'm left thinking that there's at least a 25% chance that you can get hit with a charge that will keep him in jail for several years. And that's very, very, it's insane considering how all the testimony went. But that's just terrible, terrible, terrible lawyering.
Yeah, I'm trying not to be, super black-pilled on it. We have to wait and see what happens, because
let's see how the arguments go. Because all arguments I think will be important.
Like someone said earlier, I apologize for not remembering who. Maybe it was you, Joe. We don't know what the jury's reactions are to any of this. Actually,
yeah. That's
well, I'm going to give it to someone else. Thanks, Hoglaw, for saying that. I really appreciate it.
Good job, Hoglaw.
What did I say? Oh, about juries?
Yeah.
That's true.
Yeah. I gotta step away for just a second, guys. I gotta go to the bathroom. I'll be right.
So we're
back.
gonna do intros meanwhile, so everyone can knows where to find us while you're doing that.
Yeah, absolutely. And all your links are in the description already. So yes, do some intros. I'll be right.
All right, he really needs to go.
You can find me in the pit of despair.
You can find Kurt. He's in the
So
pit
YouTube.
of despair. Yeah. No, so why don't we start with you, Uncle? We'll go around.
So I post online as Runkle of the Bailey. I do criminal defense and firearms law up here in Canada. And yeah, a lot of my commentary is Canadian law, but it's weird. So I do have some Americans who follow and are sort of going, really? That's how it works up there? So you might be interested, you might not, but check me out.
Kurt, do it.
Yeah, I'm at Uncivil Law. I've got stuff on my channel that's interesting and exciting. Please check out the interesting and exciting things at Uncivil Law. What you got, Alita?
My name is Alita. I run the YouTube channel Legal Bites, where we explain the law one bite at a time. I'm on YouTube, Twitter, Instagram, Facebook, Locals, Patreon. You can find me on any of those. I am also doing a running challenge for every 5,000 subscribers I get. I'm adding a 5K onto the previous run. And this weekend I have to run a 10K and a 15K. If you guys want to, well, they'll be on different days. So okay. It's fine. It'll be fine. But yeah, so that'll be fun. I'm doing that all the way up until 50K. And then after that, I'm not gonna do every 5,000.
130K.
I might do one for 100K.
And then after that, it's the Barkley, right? 50 is the Barkley.
Sure. I don't know.
Great.
Hoglaw.
You have no idea what you disagree to.
I don't actually. Yeah, what is the Barkley? If you're asking,
it's a bit of a challenging run.
Is it an ultra marathon?
Okay. Do you really want me to just tell you what it is flat out? Because
Sure.
it's okay. So the Barkley is this very famous run that occurs in Tennessee. It has a total elevation change of 50,000 feet over the course of about 100 miles, and it's through the woods, and it's unmarked, and you can't use GPS or anything, and it's all night and all day, and yeah, it's a thing.
That part
How many
doesn't sound so
people
fun.
died
It's a total elevation change of two Mount Everest. So yeah,
Wow.
fun times had by all. Yeah,
That's insane.
over uneven ground in the woods near a prison. Fun.
Oh my gosh. Oh wow.
You can do it. I believe in you. I'll be there for your support.
So
Oh,
anyway,
yeah. So my name's Rick Hogue. I'm actually not a litigator. I'm a lowly corporate transactions guy doing mergers and acquisitions, venture capital, working on business stuff. And my show, Virtual Legality, on YouTube is focused on talking about important legal questions through the lens of pop culture. So we talk about Spider-Man moving between Disney and Sony. We talk a lot about video games, and my God, has video games as an industry been a lot of videos. We've covered all the Activision brouhaha. We've covered Epic versus Apple and Coalition for App Fairness. We just did a video for VentureBeat and GamesBeat talking about those specific issues in gaming and the iOS store. And you can find me on YouTube at Hogue Law and on Twitter, where with the voice as it is right now, I'm not making a lot of videos, but I am tweeting a lot. So that's really healthy.
and you also do
there. Yep.
You also do a collaboration with Colin Moriarty on Sacred Symbols, right?
Yes, I'm a contributor at Last Stand Media, so I'm
There you
there 3 or 4 times a month.
My husband is very jealous. He's a big fan of you, and he's a big fan of Colin Moriarty.
I'm gonna have to put that first part in there. I got what you were saying. He loves Colin. I understand. No.
He loves watching your content too.
Sure. Yeah, no, it's been a lot of fun. So yeah, you can find me at Last Stand a couple times a month, and definitely on my YouTube channel and Twitter.
I actually discovered your channel, Hogue Law, like a couple months ago, and I've been very impressed with your knowledge, your presentation, everything. You do really fine work there. So anyone hasn't checked you out,
fantastic! Thank you so much.
And you're always so fast. That's the biggest thing. Is like one of these days, I'm gonna get a video out faster than you, and I will feel like I have reached the apex of like YouTube. Like
this
YouTube
was the week
content.
I had to skip everything this week. I didn't realize how much I liked making videos until I didn't have a voice at all, and I was like, oh God, there's another one. There's another one. There's another one. So no, absolutely, that's very kind of you to both to say. So thank you.
Yeah, so I'm Joe Neerman, also known as Good Logic. Really MAGA type of politics. I talk politics and law. I'm a New York litigator who now is a YouTube content provider, and as of this instance, I am the smallest channel in the land in this thing. And as of this instant, I'm at 9,760, and I'm really trying to get to 10K.
Yeah,
so 10K is a big break, man. Go subscribe to Good Logic. It's a huge break for the channel, huge break for my channel. It really helped me grow a lot. So go check out Good Logic. Subscribe right now.
Thank you, brother. I appreciate that.
He just commanded you to. You have to now.
So, so are we gonna go through super chats, or is there more? Is there more coming? What's the story?
What the hell is this, Legal Bites? Not only do you and Kurt leave the stream, I see you on another stream watching my stream. What is this?
Yeah, Eric Hunley wanted to check in on how you guys were doing.
We were probably when that happened, we were probably in a pretty good mood.
Yeah, I think you were in a pretty good mood when that happened. Yeah,
that's pretty funny.
Oh my God.
Oh.
Yeah, I assume again. I've got the. I'll pull it up here. I've got the live stream. It's still active. I'm just waiting for them to actually bring it back to see. So.
Oh, Grosskreutz is also on CNN now.
Oh, good. Maybe we can tune into that and watch him lie some more.
He's trying to clarify his statement.
I'm sure.
Oh, the one that the defense did not raise today, by the way, like that one, he's trying to clarify before the defense raises it that he said this thing yesterday, Judge. Maybe we should have bring him back in. Because he seemed to have lied under oath, according to his claim on Good Morning America. And yeah. I don't see that the defense brought that up. And I don't know that you want to, but maybe you do. But he
I mean,
clearly
is he
thinks he
gonna-
needs to.
By the way, I think Good Logic just made 10K.
Woohoo! Thank
Hey!
you guys.
See, we just demand it. We just
That was
demand it, and it
amazing.
happens.
That was
You just
Okay,
asked.
now I want. Now
My
I
Nice.
want
goal is to hit
20,000 people who are
20K by the
currently
end of the
subscribed to
day.
Nick.
20K is my goal today,
Unsubscribe
so-
and subscribe to me.
Look, I just want an ice cream sandwich. That's all I want. I demand an ice cream sandwich.
Yeah. No, just
Well,
make sure
maybe
you hit
if
the
you
bell.
get the
Otherwise, you'll
hand
never
from the
hear from me.
heaven that Alita has, you will get an ice cream sandwich.
I forgot to
insane.
mention I do stream nightly from Sunday to Thursday, 10 to midnight Eastern. I actually do a live stream that I end when Nick Rekieta starts his, because he's an hour behind me. So he always says I go from 11, that he goes from 11 to 2, but that's like broken Central Time. I'm going from 10 to midnight on Eastern Time, which ends up is actually 11 Central Time. So a lot of people will watch me and then flip over to him, and
So
frequently you'll see me pop up on his show when he's talking about something that just annoys me or whatever. So
apparently Andrew Bronca, Law of Self-Defense, is saying that court is done for the day. I'm not sure why the PBS live stream is still running. And I mean,
Andrew,
they-
if you're
Oh,
there,
it
can
just
you please
ended.
hit me up?
It just now ends right when I say that. Okay.
Andrew
Okay.
Bronca, can you hit me up on Twitter, please, at Nearman Joe? Because I actually wanted
Well,
to get you
he's
on.
not in here. Someone else.
Oh, I
is
thought you
now.
were saying he's in here.
No.
You're just trying to make me look bad. That's okay.
So, do you have any interest in going back and watching that whole argument over the instruction, or should I just do that separately on my channel?
I don't mind. It's up to the panel. It's not up to me. I'm just a humble lawyer.
Humble.
You can do it. I'll go get cigarettes while you guys are
Which,
doing it.
The humility part.
I was
Which
gonna say I can
instruction?
stay a little longer, but I'm probably gonna
The
go in a
provocation
half hour or so.
instruction.
Hogue,
Yeah,
add me
yeah.
up on Twitter.
Yeah.
Okay?
I want
yeah,
to
what are
watch
you on
this. I
Twitter?
want to watch this train wreck
In the
happen.
private chat, at Nearman Joe.
Okay,
I
how
just wa-
far? Oh, sorry. Go ahead.
Oh, I just watched the CNN clip that they have of him, and he just basically claims that the testimony he gave in court was false.
Good. That's good.
No, look. I agree with this caption. See them so we can set that up their arse. The full drone. So how far back do you want me to go, Kurt? Where do you want me? Do you want me to go all the way back to the beginning of the argument on provocation
It
entirely?
depends.
or-
How long is it?
It's like a half hour.
I'll let
It's a
you decide
significant-
how far back I need to go to really understand the full flare for the purposes of my depression.
I mean, yeah, it's a significant chunk.
It's up to you. I
This-
can do it separately. I don't care.
I think that, yeah, maybe we should do it separate.
Fine.
So we can give the good people of the stream a rest, an early Friday. To the chat, Monday is going to be the huge day. We've got closing arguments. I would assume that they have 5 hours of closing arguments, that if they file their motions, we may hear some oral argument about a motion or two. It would be possible. The judge will have to read jury instructions to the jury when those are finalized. We should get the results of the 6th charge, the minor in possession, on whether or not that will be dismissed, because it seems like the judge, this is the win they got today. The judge is inclined to dismiss that charge unless the state can prove 3 elements. 1, that Kyle was under 18. 2, that he was in possession of a dangerous weapon. And 3, that rifle has a barrel length shorter than 16 inches or an overall length shorter than 24 inches. They have to prove, based on what has already been admitted into evidence, those 3 issues. And the state cannot, I cannot imagine how they could prove the short barrel length, because I do remember testimony that the barrel length was standard. And so assuming they cannot prove those, it seems the judge is disinclined to include that charge entirely. That was early in the day, but
Wait,
so
Nick, if I could jump in and
yeah,
I appreciate the clarification. So there's 2 exceptions. There's the barrel length, and then there's the hunting compliance. Did the judge then give the win to the defense on the hunting compliance question, so they can't go that avenue?
Yes, basically, and Shirafisi articulated this. He says, with a barrel length of, less than 16 inches, semicolon, done. And the judge seemed to accept that interpretation, that if the semicolon there, that is a separate clause, and that once you've got that, the hunting exception is separate. And their argument is that the hunting exception basically only applies to someone who's 16 or younger.
Right, because you're always going to be in compliance with the one because it has that age cutoff.
Right. And so that's where they seem to end up on that issue.
Okay.
But yeah, it's just those three elements, I believe, which I still think as a matter of law, this should have been determined and dismissed early on. But I guess technically they hadn't stipulated to those facts.
Now, let me ask you just a technical question. I'm on their website for the court right now, and I see they have the proposed jury instructions. Can I buy those, or do I have to contact the clerk, or what do I do?
I have no idea.
In Wisconsin.
Okay, I'll contact the clerk and see if I can get a copy.
If you do, I'd love to share it. If you have to pay, I'll pay for it. So
fair enough.
And you may have to pay in cheese, though. I don't know.
It can't be worse than Los Angeles.
It depends on the cheese. It just depends on the cheese.
Yeah, I want a copy of that.
Yeah. All right. Anything else before we head out? Okay.
I did actually one thing. I just saw. I don't know if you guys have seen this or just how new it is, but apparently Kyle Rittenhouse's mom went on Fox News and saying that Joe Biden defamed her son. So I don't know if they're going to try with a defamation action. I mean, it wouldn't. Yeah, I don't know how.
That's a total non-starter.
It's a bad action. If you pick the wrong state, you're going to get slapped and it's going to hurt really bad. And
Joe Biden almost certainly enjoys absolute immunity because it's within the function of his, his job.
Although
so
that was,
it's a total
I think that was
non-starter.
when he was campaigning. It was before. He was president.
Well, fair enough.
Yeah, it was when he was campaigning, but
Fair
political
enough.
puffery. I mean,
yeah,
I don't know that you get there.
I would say more likely a more likely case would be against various media outlets, kind of like Nick Sandmann. But even still, like, I mean, if he's convicted on anything, that would harm a defamation case. And yeah, there's all kinds of issues.
I thought the closest was this week. Did you guys talk already about the CBS tweet where they accidentally said that he said that he was a murderer?
Yeah,
that's right in the line.
And but a lot of people made a big deal about that retraction and the republication as killer. That actually complies with the journalistic standards is to use killer as the proper term, which although that could then be a case of actual malice since they have standards that they deviated from. So that's interesting.
I mean, that's the thing about the word murder, but people slip up on that one.
But okay, to the stream, I will be streaming tonight at 11 p.m. Central Time, and I will be doing super chat related activities, getting through. I think I am committed to going through them, so I might be in for the long haul since I won't have an early morning tomorrow. But I will be doing that. I'll be addressing those super chats and where there are questions, I'll try and answer them based on what we have learned over the past couple days. So if you're interested in following along there, you're welcome to come by tonight, and you can follow me on Twitter or on my locals to guarantee that you get a notification. YouTube's not always great about notifying people with live streams and videos. So you can follow me. Those links are in the description as well. Make sure you follow everybody on the panel. And unless anybody has anything else, we'll wrap this stream up.
No, I just want to say thanks, and thanks for putting up with my voice.
Oh, yeah. It's been horrifically grating. Oh my goodness. How dare you? No, if you guys could all hang around for just a minute, I'll end the stream and then I'll bring us all back to say goodbye personally. All right, here we go.
Your Honor, I'm pretty sure we have a mistrial here, sir.
I'm gonna mistrial my foot up your ass. You don't shut up.